Good morning. The committees on the Judiciary and Oversight and Government Reform will come to order, and without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on oversight of FBI and DOJ actions surrounding the 2016 election. Before we begin, without objection, the MOU that Mr. Gowdy and I entered into will govern these proceedings. The chair recognizes the gentleman from New York, the ranking member of the Judiciary Committee.
Mr. Chairman, I want to express my appreciation to the staff for preparing all sorts of parliamentary objections, which we will not use. But I appreciate the chairman consulting with us on the MOU, and pursuant to our conversation, I do not object.
Chair thanks the gentleman. And chair recognizes himself for the purpose of an opening statement. I wish this hearing were not necessary. Many children grow up wanting to become FBI agents, to catch bad guys and protect the American people. I have little doubt that our witness today has done that very thing during his many years serving as an FBI special agent. A special agent's mission is a vitally important business to which we dedicate some of our best and brightest. However, this is precisely why our joint investigation is such an anomaly. We want the FBI and the Department of Justice to be off the front pages and to return to doing what they are best at, battling crime, terrorism, and espionage, and protecting all of us from harm. We don't want to read text message after text message dripping with bias against one of the two presidential candidates. We don't enjoy finding compelling evidence that the FBI director had predetermined the outcome of the case months in advance. But that is, thus far, what we have found, and these are only small pieces of the larger puzzle. The more information we acquire, the more interviews we conduct, and the more sources we contact, the more we learn. It has unfortunately taken a great deal of effort to get our executive branch agencies to cooperate with our legitimate congressional oversight. But we have made substantial progress, and it is a credit to our investigative task force members and staff. For all those in this room who continue to disparage our investigation as mere conspiracy theory, and for all those who have chosen to ignore serious irregularities and potential crimes that we have uncovered, I say this: imagine if you were under investigation and the investigator hated you, disparaged you in all manner of ways, and fraternized with another employee working on your case who also hated you, denigrated your supporters, and made crucial investigative decisions on how your case should be treated and eventually adjudicated. Would anyone sitting here today believe that this was an acceptable state of affairs, particularly at an agency whose motto is fidelity, bravery, and integrity? I think not. To my colleagues on the other side of the aisle, please replace President Trump's name with your own name in a small sample of things Mr. Strzok has said. Envision how you would feel if you found out that the chief agent investigating you as a member of Congress was making these statements: F Trump, Trump is a disaster, just went to a Southern Virginia Walmart, I could smell the Trump support. Or perhaps most alarmingly and revealingly, we'll stop it, referring directly to Mr. Trump's candidacy for president. In fact, for those who think we are wasting time in this committee, suppose all of this had been said about candidate Obama before he was elected, or even more topical about Hillary Clinton while she was running in the same election. Would we be where we are today? The only honest answer is an absolute affirmative yes. Of course we would be here, because every single Democrat would be protesting bias and discrimination against their preferred candidates by an out-of-control FBI and DOJ. So please stop saying this doesn't matter and is only the product of conspiracy theory. Instead, the American people hope you will understand that this investigation goes to the very heart of our system of justice. one that is supposed to be fair and treat everyone equally under the law. Mr. Strzok and others inside the FBI and DOJ turned our system of justice on its head, and that's why we're here and why this matters. Yesterday, Chairman Gowdy and I received a letter from my colleagues on the other side of the aisle raising numerous objections about the nature of our investigation. These claims are largely spurious, and I have responded publicly to them before. However, these claims are also revealing. The final line of that letter states that our Democratic colleagues will, quote, undertake efforts to protect their rights, end quote. I implore my friends not to continue their efforts to undermine this investigation. And as for their rights, I submit that the rights that should concern us are the rights of the American people, namely to know the facts, to trust that their law enforcement agencies are operating fairly and justly, and to feel secure in the knowledge that no one is above the law. I now recognize the ranking member of the Judiciary Committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I must say before I begin my formal statement that this country has a number of emergencies right now under the jurisdiction of this committee, which we're not spending any time or any attention to. The leading one, obviously, being the fact that 3,000 children were improperly taken away from their families, and the administration seems either unwilling or, out of total incompetence, unable to return the kids to their families, even under court order. We ought to be holding hearings about the intentions or the competence of the Department of Homeland Service, of the Department of Homeland Security on this question. Mr. Chairman, and it's of more immediate concern than this hearing, certainly. At the outset of this Congress, when my Democratic colleagues and I asked you to hold hearings about the Russian government's campaign to undermine our last election, you said no, and you offered a variety of excuses. We could not look into President Trump's overt attempts to obstruct the early stages of the Russian investigation because, you said, quote, there are other committees that have jurisdiction over part of this, unquote. You were also reluctant to interfere with the special counsel, quote, until Mr. Mueller's investigation is complete, it is redundant for the House of Representatives to engage in fact-gathering on many of the same issues. You also insisted that the House Judiciary Committee would never intrude on an active criminal investigation, claiming, perhaps erroneously, that the majority never questioned the FBI about the Clinton investigation while that investigation was still ongoing. Mr. Chairman, this joint investigation is now so far afield from the original statements that it can be difficult to discern what we are investigating at all. You initially described this inquiry as, quote, an investigation regarding charging decisions in the investigation surrounding Secretary Clinton's email server in 2016, close quote. Just a few days ago, over the course of an 11-hour interview, Republicans asked Mr. Strzok more than 200 questions about the special counsel's investigation, more than 30 questions about Mr. Strzok's personal interactions with the special counsel, and 25 questions about the FBI's use of confidential human sources, to determine who at the Trump campaign might have been compromised by a foreign government. Are we no longer going to wait until Special Counsel Mueller concludes his work, Mr. Chairman? Or perhaps the rules of this joint investigation, such as they are, operate differently now that we are approaching the midterm elections and Special Counsel Mueller is closing in on the President's close associates. In the majority's view, it seems, our job is to ask questions about the internal workings of the Special Counsel's investigation and to demand documents that lay out his strategy, but not to make any attempt to understand how the Russian government influenced our last election or any effort to protect our next election from an attack by the Russian government, a key foreign adversary. In the majority's view, it is more important to quiz Mr. Strzok about the FBI's use of confidential human sources in some wild attempt to prove President Trump's baseless claim that a, quote, spy, unquote, was planted inside his campaign, than it is to learn about the impact of exposing the identity of these sources while they are still working undercover. My Republican colleagues appear to have revealed the identity of at least one source, such source, already. In the majority's view, the text messages exchanged between Mr. Strzok and Lisa Page are a higher priority for us than President Trump's request that James Comey end the investigation into Michael Flynn, or his decision to fire Director Comey, quote, because of that Russia thing with Trump and Russia, unquote, that's a quote from the president, or his repeated attempts to fire Special Counsel Mueller directly. In the majority's view, we do not have time to conduct oversight on almost any national security issue, but we have hours on end to discuss Mr. Strzok's affair. Which brings me to my next point. I have come to expect that President Trump will tweet abhorrent things about decent people, but I hope I can expect better behavior from my colleagues. Mr. Strzok volunteered to be here today, just as he volunteered to appear 2 weeks ago for what turned out to be an 11-hour interview. You don't have to like him, but you have to treat him and any witness before this committee with respect. Questions like, do you love Lisa Page? And who did you vote for in the last election? Questions that presidents posed in his interview are not relevant to any aspect of our official business. I would say the same of the majority's treatment of Deputy Attorney General Rosenstein on June 29th, which was at best uncivil, and of the committee's treatment of Lisa Page, which has been unfair to say the least. Mr. Chairman, I agree with you that Ms. Page must eventually comply with a duly issued subpoena, but it is beneath your office to suggest, as you did this week, that her decision not to appear for deposition means, quote, she has something to hide. It is beneath our committee to call her pathetic, as Mr. DeSantis did. It has nothing to do with the swamp, as Mr. Jordan suggested. Can we not be decent to our witnesses, Mr. Chairman? Must Republicans descend to the president's level, even in his defense? I know that the majority wants a public fight with Mr. Strzok today. I expect that they will ask him questions about the special counsel's investigation that you know the FBI will not permit him to answer, as you did more than 200 times in our last meeting with Mr. Strzok, so that his decision not to answer in instructions by the FBI not to answer can be played out on cable news again and again. And I expect that Mr. Strzok walked into this room knowing that Republicans may soon call for him to be held in contempt for following the longstanding policy of the Department of Justice. FBI agents like Mr. Strzok should not comment on or even acknowledge the existence of an ongoing criminal investigation. A single decision to deviate from that protocol can cause lasting damage to our republic, as anyone who has read the Inspector General's report and his conclusions about Mr. Comey's deviations from that protocol must acknowledge. When we reach that impasse, Mr. Chairman, I hope you will think back to the statements you made about interference with the special counsel earlier this Congress and consider the consequences of our words and actions here today. The majority keeps telling us over and over again that there was bias in the Clinton investigation, bias in the Russian investigation, and that bias must never again affect an investigation at the Department of Justice. The rules that prevent Mr. Strzok from answering some of the questions today are designed to accomplish precisely that, to prevent Congress and the public from injecting bias in counsel, to prevent Congress and the public from injecting bias and politics into the special counsel's investigation or into any other investigation. When the special counsel's job is done, I'd invite all of us to join in examining his findings. Until then, Mr. Chairman, I hope we can treat our guests with common courtesy and leave the special counsel alone to do his job. I yield back.
The chair thanks the gentleman, and it's now my pleasure to recognize the chairman of the Oversight and Government Reform Committee, the gentleman from South Carolina, Mr. Gowdy, for his opening statement.
Thank you, Mr. Chairman. In our justice system, we give law enforcement officers incredible powers. The power to investigate, to search, to seize, to stop, the power to allege and accuse, the power to eavesdrop and intercept private communications, the power to look through bank records, the power to look through phone records, the power to even check what books you checked out of the library. These are awesome powers that must be used responsibly because those powers affect reputations and freedom. These awesome powers are given a correspondingly high expectation that these powers will be used fairly, lawfully, professionally, and in a manner worthy of our respect. About 2 weeks ago, FBI agent Peter Strzok was interviewed for more than 10 hours. We learned that Agent Strzok has a most unusual and largely self-serving definition of bias. Agent Strzok, despite the plain language of his texts and emails, despite the Inspector General's report, and despite common sense, doesn't think he was biased. He thinks calling someone destabilizing for the country isn't bias. He thinks promising to protect the country from someone he hasn't even begun to investigate isn't bias. He thinks promising to stop someone he is supposed to be fairly investigating from ever becoming president isn't bias. He thinks talking about an insurance policy to keep someone from becoming president isn't bias. That's for one of the folks he was investigating. He has a different set of rules for others that he's investigating. Agent Strzok thinks saying someone he is allegedly investigating should be elected president 100 million to 0 before he ever interviews her. He doesn't think that's bias. Agent Strzok thinks pronouncing someone innocent before bothering to interview more than 30 different witnesses isn't bias. He thinks claiming you can smell the Trump supporters isn't bias, but he doesn't say a single solitary word about being able to smell the support of any other candidate. To him, that isn't bias. The moment Special Counsel Bob Mueller found out about Peter Strzok's texts and emails, he kicked him off of the investigation. But that was 1.5 years too late. The text and the emails may have been discovered in May of 2017, but the bias existed and was manifest 1.5 years before that, all the way back to late 2015 and early 2016. So it wasn't the discovery of texts that got him fired. It was the bias manifest in those texts that made him unfit to objectively and dispassionately investigate. So if the bias existed in late 2015 and early 2016, and it did, his unfitness to investigate existed then as well. Agent Strzok struggled to define bias for the better part of 10 hours. For the rest of us, bias is the prejudging of a person, a group, or a thing. It usually has a negative connotation, but it is a preconceived position or a prejudgment. It is the making up of your mind ahead of time based on anything other than the facts, and that is exactly what he did. Bias is saying Hillary Clinton should win the presidency 100 million to 0 when she was still under investigation, wasn't even the nominee, hadn't been interviewed, and 30 other witnesses had also not been interviewed. In March of 2016, Agent Strzok had Clinton winning 100 million to 0, even though the investigation was far from being over. That is the prejudging of someone's innocence before all the evidence is in. On the other hand, he said Trump would be destabilizing, called him an idiot, abysmal, bigoted nonsense, called him a disaster, said he should F himself. Strzok promised to stop Trump from becoming president before the investigation even began. He talked longingly of Trump resigning 2 months after he was inaugurated and well before the special counsel investigation even began. Strzok even talked about impeachment the day special counsel was appointed. That is prejudging guilt, it is prejudging punishment, and it is textbook bias. We live in a 50-50 country, and we accept that. But we're a 100% country when it comes to having law enforcement that doesn't prejudge innocence before investigations are over and doesn't prejudge guilt and punishment before an investigation even begins. Agent Strzok had Hillary Clinton winning the White House before he finished investigating her. Agent Strzok had Donald Trump impeached before he even started investigating him. That is bias. Agent Strzok may not see it, but the rest of the country does, and it's not what we want, expect, or deserve from any law enforcement officer, much less the FBI. A fair, bias-free investigation is not a Republican or Democrat issue. It's an American issue, or at least it used to be.
Chair thanks the gentleman and recognizes the ranking member of the Oversight and Government Reform Committee, the gentleman from Maryland, Mr. Cummings, for his opening statement.
Thank you very much, Mr. Chairman. When Chairman Goodlatte and Chairman Gowdy launched their joint investigation into Hillary Clinton's emails. They promised not to interfere with the ongoing criminal investigation being conducted by Special Counsel Mueller. They were crystal clear. Let me read some of their statements. On December the 6th, Chairman Gowdy said, and I quote, "I specifically communicated to Special Counsel Robert Mueller I would not wittingly or unwittingly interfere with an ongoing criminal probe," end of quote. On March 18th, Chairman Gowdy said, and I quote, "I've been really very clear. Leave him alone. Let him do his job," end of quote. Chairman Gowdy went on to offer advice directly to the president. And this is what he said, and I quote, "My advice to the president is the same thing I just told his lawyer. Give Bob Mueller the time, the independence, and the resources to do the job." He went on to say that when you are innocent, if the allegations of collusion with the Russians, and there's no evidence of that, and you are innocent of that, act like it, end of quote. This was the advice that Chairman Gowdy gave to the President of the United States of America. And let me be very clear, I have a tremendous amount of respect for the Chairman of the Oversight Committee. Chairman Goodlatte echoed those comments, declaring that he and Chairman Gowdy had, and I quote, "no intentions of interfering with the substantive investigation of Mr. Mueller," end of quote. But now they are doing the opposite. Behind closed doors, they're asking individuals involved in the Russia investigation hundreds of questions about confidential human sources, FISA applications, and potential witnesses in the Special Counsel's criminal probe. In public, they're holding emergency hearings, issuing unilateral subpoenas, and threatening contempt and impeachment. They even demanded that the top Justice Department law enforcement officer in charge of this investigation, and I quote, "finish it the hell up," end of quote. So what has changed? What has changed? Why did our chairman promise not to interfere wittingly or unwittingly, but then suddenly launch this aggressive attack against our special counsel? There has been one obvious development. The special counsel has now obtained 5 guilty pleas and indicted 18 others, including some of President Trump's closest advisors. Here are the individuals who are already admitted their guilt. Michael Flynn, President Trump's national security advisor. He pleaded guilty to lying about his secret communications with the Russians, making false statements to the FBI, and impeding the investigation while he worked at the White House last year. Let me underscore, these are not allegations. These are admissions. President Trump's national security advisor admitted that he committed these crimes, and he is now cooperating with the special counsel. Rick Gates, President Trump's deputy campaign chairman. He pleaded Is there rules for that, Mr. Chairman?
Mr. Chairman, is there
Are there any rules
point of
against
order,
what
Mr.
they are doing? Cite the rule. Cite the rule if there's a rule against what they are doing. Cite the rule.
Based on verifiable.
Names, faces, titles, and the rule, and the word guilty.
There is.
The gentleman may proceed.
Thank you very much, Mr. Chairman. Let me underscore, these are not allegations, these are admissions. President Trump's top national security advisor admitted and he committed these crimes, and he is now cooperating with the special counsel. Rick Gates, President Trump's deputy campaign chairman, he pleaded guilty to, quote, conspiracy against the United States of America, end of quote, to intentionally engaging in a variety of criminal schemes and to lying to the special counsel and the FBI last year and even this year. He admitted to committing those crimes. He is also cooperating with the special counsel. George Papadopoulos, President Trump's foreign policy advisor, he pleaded guilty to making false statements to the FBI in 2017 about when he first learned that the Russians had dirt on Hillary Clinton. Also now cooperating with the special counsel. Richard Pinedo, digital marketing strategist, pleaded guilty to identity fraud and trafficking in hundreds of stolen bank account numbers over the internet, which were bought by Russians to interfere with the 2016 election. And Alex van der Zwaan, the son-in-law of a Russian oligarch, pleaded guilty to lying to special counsel and the FBI in November about his work with President Trump's campaign chairman, Paul Manafort, for foreign nationals aligned with Russia. Of course, this does not include Mr. Manafort himself, who is scheduled to begin his criminal trial later this summer. He is sitting in solitary confinement after allegedly engaging in witness tampering. This also does not include Michael Cohen, the president's longtime lawyer. At this moment, he may be considering whether to cooperate with special counsel. At the last Judiciary Committee hearing, Chairman Gowdy said that if the special counsel has evidence of a crime, he should submit it to the grand jury. As Chairman Gowdy himself said, if you are innocent, act like it. Today, I urge our chairman to change course and to keep their promises to protect the integrity of the special counsel's ongoing investigation, and instead of asking hundreds of questions that undermine it, to work with him. And with that, Chairman, I yield back.
We welcome our witness. And Mr. Strzok, if you would please rise, I'll begin by swearing you in. Do you swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record show that the witness answered in the affirmative. Mr. Peter Strzok is a Deputy Assistant Director of the Human Resources Division of the FBI. Mr. Strzok has worked at the FBI for approximately 22 years. Prior to his current assignment, he was a Deputy Assistant Director in the Counterintelligence Division. It was his assignment in that division that brings him before the committees today as we continue our investigation. Your written statement will be entered into the record in its entirety, and we ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. Mr. Strzok, you may begin.
Chairman Goodlatte and Gowdy, Ranking Members Nadler and Cummings, thank you for the opportunity to testify before your committees again, this time in an open hearing.
Prior to his current assignment, he was a Deputy Assistant Director in the Counterintelligence Division. It was his assignment in that division that brings him before the committees today as we continue our investigation. Your written statement will be entered into the record in its entirety, and we ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. Mr. Strzok, you may begin.
Chairman Goodlatte and Gowdy, Ranking Members Nadler and Cummings, thank you for the opportunity to testify before your committees again, this time in an open hearing. I testify today with significant regret, recognizing that my texts have created confusion and caused pain for people I love. Certain private messages of mine have provided ammunition for misguided attacks against the FBI, an institution that I love deeply and have served proudly for over 20 years. I'm eager to answer your questions, but let me first address those much discussed texts. Like many people, I had and expressed personal political opinions during an extraordinary presidential election. Many contained expressions of concern for the security of our country, opinions that were not always expressed in terms I'm proud of. But having worked in national security for 2 decades and proudly served in the U.S. Army, those opinions were expressed out of deep patriotism and an unyielding belief in our great American democracy. At times, my criticism was blunt, but despite how it's been characterized, it was not limited to one person or to one party. I criticized various countries and politicians, including Secretary Clinton, Senator Sanders, then candidate Trump, and others. But let me be clear, unequivocally and under oath, not once in my 26 years of defending our nation did my personal opinions impact any official action I took. This is true for the Clinton email investigation, for the investigation into Russian interference, and for every other investigation I've worked on. It is not who I am, and it is not something I would ever do, period. I understand that my sworn testimony will not be enough for some people. After all, Americans are skeptical of anything coming out of Washington. But the fact is, after months of investigations, there's simply no evidence of bias in my professional actions. There is, however, one extraordinarily important piece of evidence supporting my integrity, the integrity of the FBI, and our lack of bias. In the summer of 2016, I was one of a handful of people who knew the details of Russian election interference and its possible connections with members of the Trump campaign. This information had the potential to derail and quite possibly defeat Mr. Trump, but the thought of expressing that or exposing that information never crossed my mind. That's what FBI agents do every single day, and that's why I'm so proud of the Bureau. And I'm particularly proud of the work that I and many others did on the Clinton email investigation. Our charge was to investigate it competently, honestly, and independently, and that's exactly what happened. I'm also proud of our work on the Russian interference investigation. This is an investigation into a direct attack by a foreign adversary, and it is no less so simply because it was launched against our democratic process rather than against a military base. This is something that all Americans of all political persuasions should be alarmed by. In the summer of 2016, we had an urgent need to protect the integrity of an American presidential election from a hostile foreign power determined to weaken and divide the United States of America. This investigation is not politically motivated. It is not a witch hunt. It is not a hoax. I expect that during this hearing, I'll be asked about that ongoing investigation. Where the FBI has directed me not to answer, I will abide by the FBI's instructions. But let me be clear. This is not because I don't want to answer your questions. If I were permitted to answer, I would. And the answers would doubtless be disappointing to the questioners and undermine the conspiracy narrative being told about the Russia investigation. I understand we're living in a political era in which insults and insinuation often drown out honesty and integrity. But the honest truth is that Russian interference in our elections constitutes a grave attack on our democracy. Most disturbingly, it has been wildly successful, sowing discord in our nation and shaking faith in our institutions. I have the utmost respect for Congress's oversight role, but I strongly believe today's hearing is just another victory notch in Putin's belt and another milestone in our enemy's campaign to tear America apart. As someone who loves this country and cherishes its ideals, it is profoundly painful to watch and even worse to play a part in. Mr. Chairman, I welcome your questions.
We will now proceed under the 5-minute rule with questions. I'll begin by recognizing the chairman of the Oversight and Government Reform Committee, Mr. Gowdy.
Thank you, Mr. Chairman. Agent Strzok, the FBI investigation into potential Russia collusion with the Trump campaign began on July 31st, 2016. You drafted the originating document. You approved the originating document. You were the point of contact on the originating document, and the FBI has represented to Congress that nothing from an investigative standpoint with respect to Russian collusion and the Trump campaign began before July 31st, 2016. But 10 days before the investigation even began, 10 days before you drafted the originating document, approved the originating document with the point of contact from an investigative standpoint of destabilizing. With respect to Russian collusion and the Trump campaign began before July 31st, 2016. The second one caught my attention, the second dictionary definition. To call something such as a government to be incapable of functioning or surviving. That's a pretty significant allegation to make 10 days before you even began to investigate someone. So that was before July 31st. I want to ask you in that first week, we'll go ahead and up it to 8 days, between July 31st and August 8th, how many interviews did you conduct related to the alleged collusion between Russia and the Trump campaign?
So, Congressman, as you know, counsel for the FBI, based on the special counsel's equities, has instructed me not to answer questions about the ongoing investigation.
I'm asking for a number.
Russian attempts to interfere.
Agent Strzok, I'm asking for a number. I haven't gotten to the names. How many people had you interviewed between the beginning of it on July 31st and August the 8th? It's an 8-day time period. We're a week into an investigation. How many people had you interviewed?
Congressman, I understand your question. I appreciate it, and I would very much like to answer. But as I've stated, as you know, that counsel of the FBI, based on the special counsel's equities, have directed me not to answer any questions about the ongoing investigation into Russian attempts to interfere.
The gentleman will suspend and the clock will suspend. Mr. Strzok, you are under subpoena and are required to answer the question. Are you objecting to the question? If so, please state your objection.
Mr. Chairman, I object.
The gentleman does not have standing to object. There is no
point of order.
No point of order here. The
Point of order, it should be heard.
gentleman will state his point of order.
My point of order is that intentionally or otherwise, this demand puts Mr. Strzok in an impossible position. He is still an employee of the FBI, and FBI counsel has instructed him not to answer the question. If we have a problem with this policy, we should take it up with the FBI, not badger Mr. Strzok.
The gentleman's point of order is not well taken.
It's right on point.
No, it's not. Mr. Strzok, are you objecting to the question? And if so, please state your objection.
Mr. Chairman, two things. One, I do not believe I am here under subpoena. I believe I am here voluntarily. Second, I will not, based on direction of the FBI to me, Based on that, I will not answer that question because it goes to matters which are related to the ongoing investigations being undertaken by the Special
Mr.
Counsel's
Strzok,
Office.
you have not stated a valid legal basis for not responding to a question directed to you by a member of the United States House of Representatives, and you are overruled.
Point of order, Mr. Chairman.
Let me continue. Your testimony is essential to this hearing and to our oversight and information gathering functions with regard to the actions taken and decisions made by the Department of Justice and the Federal Bureau of Investigation in 2016 and 2017. I am specifically directing you to answer the question in response to our subpoena, notwithstanding your objection.
Point of order, Mr. Chairman.
Mr. Strzok, please be advised that you can either comply with the committee's directive to answer the question or refuse to do so, the latter of which will place you at risk of a contempt citation and potential criminal liability.
Point of order.
Do you understand that?
Point of order, Mr. Chairman.
The question is directed to the witness.
And I have a point of order before he answers the question.
The point of order is not well taken until...
You don't know what the point of order is. You can't say it's not well taken.
The point of order, the witness will answer the question.
Mr. Chairman, I raise my point of order, and I insist on it.
What is the point of order?
The United States Attorney's Manual instructs department personnel not to respond to questions about the existence of an ongoing investigation or comment on its nature or progress. In a letter to Congressman John Linder in 2000, referred to as the Linder letter, the department made this policy explicitly applicable to requests from Congress. Quote, although Congress has a clearly legitimate interest in determining how the department enforces statutes, congressional inquiries during the pendency of a matter pose an inherent threat to the integrity of the department's law enforcement and litigation functions, unquote. Therefore, the question being directed at the witness is out of order. The witness's declination to answer it as against the instructions of the FBI pursuant to FBI policy, which is enforces statutes, congressional inquiries during the pendency of a matter pose an inherent threat to the integrity of the department's law enforcement and litigation functions, unquote. Therefore, the question being directed at the witness is out of order. The witness's declination to answer it as against the instructions of the FBI pursuant to FBI policy, which is necessary so as not to allow us to subvert an ongoing criminal investigation, he is right. And he should not answer the question.
The gentleman has not stated a valid point of order.
I will appeal the ruling of the chair in that case.
Nonetheless, the United States Supreme Court has recognized that it is unquestionably the duty of all citizens to cooperate with the Congress in its efforts to obtain the facts needed for intelligent legislative action. It is their unremitting obligation to respect the dignity of the Congress and its committees and to testify fully with respect to matters within the province of proper investigation.
Mr. Chairman, Mr. Chairman, you know, or we all know, that if we were to ask a question of a witness about a military secret, if we were to ask him, how does the H-bomb work? He could not answer that question. This is the same thing.
That is a classification issue, not an issue of whether or not this is a valid question for which...
I appeal the ruling of the chair.
It's not a point of order.
He has ruled that it's not a point of order.
That is not a ruling. Mr. Strzok?
Mr. Chairman, I insist on my point of order, and I insist on appealing the ruling of the chair.
Mr. Strzok, knowing the advice that
Point of order, Mr. Chairman. Point of order. I believe there's a point of order that's been raised, and you've ruled we have a right now to answer Mr. Nadler's.
It is not a valid point of order. The chair has already
repress it, Mr. Chairman, because you don't.
On that ruling.
Point of order, Mr. Chairman.
Mr. Strzok.
Mr. Chairman, I appeal the ruling of the chair that you have just made on that, on whether the...
You have not stated a valid point of order.
And that is your ruling, and I appeal it.
That is not an appealable...
Point of order. Yes, it is, Mr. Chairman. Appealing the ruling of the chair is exactly what he's requesting. He's appealing it. That requires a vote to either sustain it or overrule it.
The gentleman from New York has not cited a rule of the House that is being violated. Therefore, it is not a point of order.
That's your ruling.
I appeal that ruling of the chair.
Mr. Chairman, is it not appropriate to also interject
the attorney-client privilege, which cannot be overridden, and is a rule of the House to the extent that witnesses have the right to an attorney-client privilege in this House. And that is what this witness is asserting, attorney-client privilege, and he has been advised not to answer the question.
The gentlewoman will suspend. The gentleman has not raised the attorney-client privilege. He has said that he's been instructed by the FBI not to answer the question. Now,
by lawyers.
He knows the advice I have just given him. If he would like, I'll restate it. But knowing this, will you answer the committee's question as directed, or do you refuse to answer the committee's question?
Point of parliamentary inquiry,
the ruling of the
Mr.
chair that
Point
my
of parliamentary
order was
inquiry.
not in order.
Point of parliamentary inquiry, Mr. Chairman.
The gentleman from South Carolina has the time. A parliamentary inquiry is not in order during the gentleman's time. The chair is instructing the witness to answer the question, and the question to you is,
Mr. Chairman.
will you answer the committee's question as directed, or do you refuse to answer the committee's question?
Mr. Chairman, I move to adjourn.
Second.
You're not recognized for that purpose.
Mr. Chairman, I think you have no choice but to recognize such a motion.
I do not have.
It's Mr. Gowdy's time. It's not.
Are you just going to make up rules as we go along? Is that,
The motion is not in order during the time controlled by the gentleman from South Carolina.
I appeal that ruling of the chair.
Mr. Strzok, will you
Chairman, I
answer?
appeal your ruling of the chair that my motion to adjourn is not in order.
The gentleman is not in order.
That may be, but I appeal your ruling.
The gentleman is not recognized.
Just take back over your time and just fire away.
Knowing this, will you answer the committee's question as directed, or do you refuse to answer the committee's question?
Mr. Chairman, as you know, counsel for the FBI has directed me not to answer questions about the ongoing investigation. As you also know, counsel for the FBI is sitting here behind me. May I consult with them?
You may consult with your own counsel.
But I may not consult with the FBI's counsel?
Only with your own counsel.
Mr. Chairman, there's no basis for that. He can consult with the FBI counsel. He's an FBI employee.
The gentleman is not recognized.
And the chairman is not being proper.
The chairman is being proper.
the witness can't be directed not to confer with his attorney.
The FBI is not his attorney. His attorney is seated behind him. If he wishes
He's an
to consult
employee
with
of
his
the
attorney,
FBI,
as he's already done, he may do so.
And his attorney may consult with the FBI attorney?
Isn't the privilege that of the
Order, Mr. Chairman. Will the committee also consider contempt for Mr. Bannon, who refused to answer Mr. Gowdy's questions when he was actually under subpoena?
That is not a proper point of order in this hearing.
Parliamentary inquiry.
Mr. Gowdy, do you remember
Parliamentary inquiry.
The time is controlled by the gentleman from
Parliamentary inquiry.
A parliamentary inquiry is
Mr.
not
Bannon,
in
will you
order
answer your
when the
questions
gentleman
under subpoena,
from
Mr.
South Carolina controls the time.
Agent Strzok, just so the record's clear, because it's been a little while, I didn't ask you the content of those interviews. I didn't ask you the names of who you interviewed. I asked you whether or not you interviewed anyone from July the 31st until August the 8th. And I find it interesting that the FBI will tell us no interviews were conducted before July 31st. That apparently doesn't impact an ongoing probe. But between July 31st and August 8th, it does. Here's the good news. I already know the answer to it. I went and looked at the file. The first interview that I can find is on August the 11th of 2016, which is 11 days after it began, which makes me wonder, on August the 6th, so you hadn't interviewed anyone, you're investigating this alleged Russian collusion with the Trump campaign, you're the lead investigator, you originated the investigation, you're the point of contact, you drafted the document, and here you are before you've interviewed a single solitary witness saying F Trump. Then that same day, your colleague, Lisa Page, wrote, "Maybe you're meant to protect the country from that menace." And you responded, "I can protect the country at many levels." We're not even a week into an investigation that you originated, approved, were the contact for. You hadn't interviewed a single solitary soul until August the 11th, and you're already promising to protect the country from that menace, Donald Trump. And then on August the 8th, you still hadn't interviewed anyone. You're 8 days into your Russian collusion with the Trump campaign investigation, and you got another text from your colleague, Lisa Page. Trump's not ever going to become president, right? Right? And you replied, no. No, he's not. We'll stop it. By the time you promised to stop him from becoming president on August the 8th, how many interviews had you conducted?
Mr. Gowdy, so two answers to that. One, with regard to how many interviews had or had not been conducted, I've been directed by counsel for the FBI not to answer that question. Second, sir, I think it's important to take those texts in the context of how they were written and what they meant.
And someone may ask you that question, Agent Strzok, but I didn't. I asked you how many people you interviewed before you wrote it. If you want to get into context, let one of my other colleagues do that with you. Here's what I want to know. Who's the he and he's not?
He is then candidate Trump.
So when you said, no, Donald Trump's not, in connection with the question, going to become president, what's the it?
Chairman Gowdy.
We'll stop it.
Chairman Gowdy, that text needs to be taken in the context of which
I'm asking, look, if you want to have a debate over a two-letter word, we're going to have to do that some other time. What and who did you mean by it?
Mr. Gowdy, as I've stated, that text was written late at night in shorthand.
I don't care when it was written. I don't care whether it was longhand, cursive. I don't care about any of that. I want to know what it meant, Agent Strzok.
It would be his candidacy for the presidency, and my sense that the American population would not vote him into office.
Right. Well, we hadn't gotten to the will yet.
Well, I'm trying to cut to the chase and explain the text.
The will is the American people. Is that right? That's your testimony. The will stop it. You were speaking on behalf of the American people. Is that correct?
Mr. Gowdy, what my testimony is and what I said during extensive asking of this question during my prior interview is I don't recall writing that text.
Are you denying writing the text?
What I can tell you is that text in no way suggested that I or the FBI would take any action to influence the candidacy of
Agent Strzok, that is a fantastic answer to a question nobody asked.
Yeah, Mr. Gowdy, you asked what I meant.
My question to you is
Chairman,
the
the witness
will.
going to be permitted to answer the question being posed?
Gentleman will suspend. After the conclusion of Mr. Gowdy's questions, if there is a question that he has not had the opportunity to answer, we'll be given additional time to do that. Witness will.
Well, you look forward to that.
Mr. Gowdy's now, and he will not be interrupted by others.
So your testimony.
His time has expired, Mr. Chairman.
Your testimony
by 2.5 minutes.
It's going to be tough for me to get through it if I keep getting interrupted. Your testimony a couple of weeks ago was the we meant the American people, which I found confusing because on November the 7th, which is the day before the election, you said this. You were concerned that those same American people that you were speaking on behalf of might actually elect Donald Trump president. So you said, OMG, this is effing terrifying. I think we know what effing means. I'm pretty sure we have OMG down too. What was terrifying about those same American people you trusted to stop him in August, not stopping him in November? What was so terrifying about that, Agent Strzok?
Mr. Gowdy, I do not have a copy of the transcript. We have not been provided that transcript.
It's your text. It's not the transcript, it's your text.
Mr. Gowdy, what I would say in that is, one, I was not referring to the American electorate at all. The American electorate I respect in their decisions, and their right to vote is absolutely a cornerstone of our democracy. So at no time did I insult or call into question the judgment or the power of the American electorate. What I was expressing in that text is my personal belief and my personal sense of how I saw and what I believed in the potential upcoming administration.
And see, that's what I find so confounding, because in August you blamed the we on the American people, that the American people would stop it, because you don't want it to be you and Lisa Page.
Mr. Chairman,
and you don't want it to be the FBI.
Are we not given 5 minutes to answer questions? We have indulged this harassment 9 minutes.
The chair.
Judiciary and the Oversight Committee. I thought
the gentleman will suspend. The chair, in agreement with The ranking members of both committees agreed that there would be liberality in the questioning by the chairman and the ranking members of each committee. The gentleman will continue.
What I find
Then,
confounding,
Mr. Chairman,
Agent
we
Strzok,
expect that liberality on every one of our questionings.
what I find confounding, Agent Strzok, is you were counting on the American people. That was the we you referenced in August when you said, we'll stop it. But the American people didn't stop it. He actually won. So then we go to March of 2017, and you're already talking longingly about him resigning. And then we go to the day that Special Counsel Mueller, well, before we go to that, that's March of 2017. March of 2016, you wrote, God, Hillary should win 100 million to 0. And I'm assuming Hillary would be former Secretary of State Hillary Clinton?
That's correct.
All right. In March of 2016, weren't you investigating her for potential mishandling of classified information?
We were.
Had you interviewed her yet?
No.
Had you interviewed more than 30 other witnesses that wound up being interviewed?
I would have to check the case file, but I'll take your representation. That's
well, if she had said something incriminating in your interview that took place months later of her, would she have won 100 million to 0 then?
likely not, no.
Well, then why wouldn't you wait until the investigation was over before you have her the nominee and winning a general election against an opponent that hadn't even been named yet? 100 million to 0, Agent Strzok? That's how bad she should win?
Mr. Gowdy, those personal expressions of my observing the political process of the presidential primaries had no bearing on my actions of any investigation, to include the investigation of Secretary Clinton.
You couldn't think of
or anybody else. Sir,
you couldn't think of a single person that would not vote for Hillary Clinton for president? 100 million to 0, Agent Strzok?
Sir, that was clearly hyperbole, which I...
Well, let's say it was hyperbole. Let's divide it by 10. How about we say it was hyperbolic and divide it by 10? 100 million divided by 10, I'm pretty sure is 10 million. 0 divided by 10 is still 0. You couldn't think of a single solitary person that was going to vote for her for president before you interviewed her and while you were supposed to be investigating her.
Congressman, clearly that's not the truth. Clearly I could envision millions of Americans who are likely and did vote for then candidate.
Well, you wrote it.
My point, sir.
Did you write it? Did you write that text?
I did write that, sir.
Okay. Were you under duress?
Political expression engaging in hyperbole.
Were you under duress?
Asked and answered.
So that was clearly hyperbole, which I...
Well, let's say it was hyperbole. Let's divide it by 10. How about we say it was hyperbolic and divide it by 10? 100 million divided by 10, I'm pretty sure is 10 million. 0 divided by 10 is still 0. You couldn't think of a single solitary person that was going to vote for her for president before you interviewed her and while you were supposed to be investigating her.
Congressman, clearly that's not the truth. Clearly I could envision millions of Americans who are likely and did vote for then candidate.
Well, you wrote it.
My point, sir.
Did you write it? Did you write that text?
I did write that, sir.
Okay. Were you under duress?
Political expression engaging in hyperbole.
Were you under duress?
Asked and answered over and over again.
The gentlewoman will suspend. The gentleman from South Carolina controls the time.
All right, we're going to go into one other time period. May 17th, 2017, Bob Mueller is appointed. Your friend Jim Comey's been fired. He's already leaked the memos to his law professor friend, and Mueller is special counsel. Do you remember how long it took for you to start talking about impeachment after Bob Mueller was appointed?
I don't, sir.
1 day. 1 day. And you were talking about impeachment. And for anyone who may have missed it the day after his appointment, Agent Strzok, you did it again 5 days later. Now, how many interviews had you done as part of the special counsel team within the first 5 days of his appointment?
Sir, again, same answer as before. I can't get into details.
Right, and the answer is also the same. It's 0. No interviews had been done.
I don't know if that's true or not.
No interviews had been done by August the 8th, when you're talking about stopping him and how terrifying it would be for him to win and how you can protect the country. And no interviews had been done before you're talking about impeachment of the president. But no wonder
Chairman,
Bob Mueller kicked you off of the investigation, Agent Strzok. My question is, if you were kicked off when he read the text, shouldn't you have been kicked off when you wrote them?
Not at all.
Well, it wasn't the discovery of your text, Mr. Strzok. It was the existence of your bias that got you kicked off.
No, Mr. Gowdy, it wasn't. I do not have bias. My personal opinions in no way.
Well, then why did you get kicked off? Why'd you get kicked off?
Mr. Gowdy, my understanding of why I was kicked off was that based on an understanding of those texts and the perception that they might create is something that
hang on a
Special
second,
Counsel
Agent
Mueller,
Strzok. Hang on a second. Perception.
Integrity.
You're saying it was the perception. There are 13 Democrats on the special counsel probe, including one who went to what he hoped was a victory party. That's a perception problem, too. They weren't kicked off. You were. Why were you kicked off?
Mr. Gowdy, I cannot speak to Special Counsel Mueller's
How long
staffing
did you talk to
decisions
him?
or the reasons why he did or didn't.
How long did you talk to him when he let you go?
Witness answer the question.
Witness will be afforded the opportunity to answer the question if there is a question he wants to answer after Mr. Gowdy's time.
My recollection, it was a short meeting, somewhere between 15 to 30 minutes, probably around 15 minutes.
And your testimony is Bob Mueller did not kick you off because of the content of your text. He kicked you off because of some appearance that he was worried about.
Sure. My testimony, what you asked and what I responded to, was that he kicked me off because of my bias. I'm stating to you it is not my understanding that he kicked me off because of any bias, that it was done based on the appearance. If you want to represent what you said accurately, I'm happy to answer that question, but I don't appreciate what was originally said being changed.
I don't give a damn what you appreciate, Agent Strzok. I don't appreciate having an FBI agent with an unprecedented level of animus working on 2 major investigations during 2016.
The chair recognizes the gentleman from Maryland, Mr. Cummings.
Point of order,
Mr. Chairman, can I respond to
answer
some
the
of the
questions that you promised him he would have an opportunity to answer? We endured 15 minutes of badgering of the witness. Can he be allowed now to answer as you promised, Mr. Chairman?
The gentleman will suspend. The witness at any time can ask for additional time to respond to any member's question if the time has been
You
ended.
said you were going to give him that opportunity at the end.
I am giving him that opportunity.
Mr. Chairman, may I respond to?
Yes, you may.
Yes, Mr. Gowdy. Sir, I think it's important when you look at those texts that you understand the context in which they were made and the things that were going on across America. In terms of the text that we will stop it, you need to understand that that was written late at night, off the cuff, and it was in response to a series of events that included then-candidate Trump insulting the immigrant family of a fallen war hero. And my presumption, based on that horrible, disgusting behavior, that the American population would not elect somebody demonstrating that behavior to be president of the United States. It was in no way, unequivocally, any suggestion that me, the FBI, would take any action whatsoever to improperly impact the electoral process for any candidate. So I take great offense and I take great disagreement to your assertion of what that was or wasn't. As to the 100 million to 1, that was clearly a statement made in jest and using hyperbole. I, of course, recognize that millions of Americans were likely to vote for candidate Trump. I acknowledge that is absolutely their right. That is what makes our democracy such a vibrant process that it is. But to suggest somehow that we can parse down the words of shorthand textual conversations like there's some contract for a car is simply not consistent with my or most people's use of text messaging. I can assure you, Mr. Chairman, at no time in any of these texts did those personal beliefs ever enter into the realm of any action I took. Furthermore, this isn't just me sitting here telling you, you don't have to take my word for it. At every step, at every investigative decision, there are multiple layers of people above me, the assistant director, executive assistant director, deputy director, and director of the FBI, and multiple layers of people below me, section chiefs, supervisors, unit chiefs, case agents, and analysts, all of whom were involved in all of these decisions. They would not tolerate any improper behavior in me any more than I would tolerate it in them. That is who we are as the FBI. And the suggestion that I, in some dark chamber somewhere in the FBI, would somehow cast aside all of these procedures, all of these safeguards, and somehow be able to do this is astounding to me. It simply couldn't happen. And the proposition that that is going on, that it might occur anywhere in the FBI, deeply corrodes what the FBI is in American society, the effectiveness of their mission, and it is deeply destructive.
Mr. Chairman, I have a motion. I have a Rule 11 motion, Mr. Chairman. Clause 2. I move to subpoena Steve Bannon. Mr. Bannon was a witness in the House Intelligence Committee investigation. He was under subpoena. He refused to answer questions by Mr. Gowdy.
The gentleman is not recognized. The chair recognizes the gentleman from Maryland, Mr.
Chairman,
Cummings,
a motion
for his
is always in
question.
order. A motion is always in order, Mr. Chairman. It's Rule 11, Clause 2.
I will yield to Ms. Swalwell for 1 minute.
Mr. Chairman, I move to subpoena Steve Bannon. In our House Intelligence investigation, he was under subpoena. He refused a number of times to answer questions of Mr. Gowdy. Mr. Gowdy appears to have a sincere interest in getting to the bottom of what happened, and so I move under Rule 11 to bring Mr. Bannon to this committee. Also, Mr. Chairman is in receipt of Devin Nunes's letter to our committee recommending that the Judiciary Committee continue on the House Intelligence Committee's investigation into Russia and recommended witnesses. So I move now for consideration for Mr. Bannon to be subpoenaed. And if he refuses, for contempt proceedings to occur.
Mr. Chairman. Mr. Chairman,
Chair recognizes
I object to consideration.
The chair, the ayes have
Mr.
it.
Chairman, I ask for a recorded vote.
Point of
I ask for a
parliamentary inquiry,
recorded
Mr. Chairman.
vote.
Mr. Chairman, point of parliamentary inquiry.
Gentleman will state his point of parliamentary inquiry.
On the vote to table, or for that matter, on the vote to appeal the ruling of the chair, do we take separate votes of the two committees, or one vote of everything?
My understanding was that both you and Mr. Cummings were satisfied with one roll call vote. But we'll go through each committee in order, and then we'll take the cumulative vote after the conclusion of both committees.
I just wanted to clarify that point.
Mr. Chairman, I had asked for a recorded vote.
The recorded vote has been requested, and the clerk will call the roll. The question is on the motion to table the appeal of the ruling of the chair. The clerk for the Judiciary Committee will commence.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Smith? Mr. Smith votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. King?
Aye.
Mr. King votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes yes. Mr. Marino? Mr. Marino votes yes. Mr. Gowdy?
Pass.
Mr. Labrador? Mr. Collins? Mr. Labrador votes aye. Mr. Collins? Mr. Collins votes aye. Mr. DeSantis? Mr. DeSantis votes aye. Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Rutherford? Mr. Rutherford votes aye. Ms. Handel? Ms. Handel votes yes. Mr. Rothfuss? Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Mr. Cohen? No. Mr. Cohen votes no. Mr. Johnson of Georgia? No. Mr. Johnson votes no. Mr. Deutsch? No. Mr. Deutsch votes no. Mr. Gutierrez? No. Mr. Gutierrez votes no. Ms. Bass? No. Mr. Richmond? No. Mr. Richmond votes no. Mr. Jeffries? Mr. Cicilline?
No.
Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? No. Mr. Raskin votes no. Ms. Jayapal? No. Ms. Jayapal votes no. Mr. Schneider? No. Mr. Schneider votes no. Ms. Demings? No. Ms. Demings votes no.
The clerk of the Oversight and Government Reform Committee will call the roll.
Mr. Gowdy?
Pass.
Mr. Gowdy passes. Mr. Duncan?
Aye.
Mr. Duncan votes aye. Mr. Issa?
I am aye for both committees.
Mr. Issa votes aye. Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Sanford?
Aye.
Mr. Sanford votes aye. Mr. Amash? Mr. Gosar?
Aye.
Mr. Gosar votes aye. Mr. Desjardins? Aye. Mr. Desjardins votes aye. Ms. Fox? Mr. Massey? Aye. Mr. Massey votes aye. Mr. Meadows? Aye. Mr. Meadows votes aye. Mr. DeSantis. Mr. DeSantis votes aye. Mr. Ross. Mr. Ross votes aye. Mr. Walker. Mr. Walker votes aye. Mr. Blum. Mr. Blum votes aye. Mr. Heiss. Mr. Heiss votes aye. Mr. Russell. Mr. Russell votes aye. Mr. Grothman. Mr. Grothman votes aye. Mr. Hurd. Mr. Palmer. Mr. Palmer votes aye. Mr. Comer.
Yes.
Mr. Comer votes yes. Mr. Mitchell. Mr. Gianforte.
Yes.
Mr. Gianforte votes yes. Mr. Cummings. Mr. Cummings. Mr. Cummings votes no. Ms. Maloney. No. Ms. Maloney votes no. Ms. Norton.
No.
Ms. Norton votes no. Mr. Clay. Mr. Lynch.
No.
Mr. Lynch votes no. Mr. Cooper. No. Mr. Cooper votes no. Mr. Connolly.
Nay.
Mr. Connolly votes nay. Ms. Kelly. Nay. Ms. Kelly votes nay. Ms. Lawrence. Nay. Ms. Lawrence votes nay. Ms. Watson-Coleman. No. Ms. Watson-Coleman votes no. Mr. Krishnamurthy.
No.
Mr. Krishnamurthy votes no. Mr. Raskin.
No.
Mr. Raskin votes no. Mr. Gomez. Mr. Welch. No. Mr. Welch votes no. Mr. Cartwright.
No.
Mr. Cartwright votes no. Mr. Desaulniers. No. Mr. Desaulniers votes no. Ms. Plaskett. No. Ms. Plaskett votes no. Mr. Sarbanes. Mr. Sarbanes votes no.
Mr. Chair, how is Mr. Gowdy recorded?
Mr. Gowdy passed.
The clerk will call the
Pass is
roll.
not a vote.
The clerk of the Judiciary Committee will call the roll of members who have not yet been recorded.
Mr. Issa? Yes. Mr. Issa votes yes. Mr. Gowdy? Mr. Buck? Aye. Mr. Buck votes aye. Ms. Roby? Mr. Rothfuss? Aye. Mr. Rothfuss votes aye. Ms. Bass? Mr. Jeffries?
I've been asked by the minority and the majority counsel to advise members that their votes will only be counted once if they're on both committees. And the clerk of the Oversight and Government...
Mr. Chairman, point of order. On what basis would that rule be, since each committee is voting separately on that?
Procedurally, we have agreed to one unified vote. The clerk of the Oversight and Government Reform Committee will call the roll of those members who have not voted.
Mr. Gowdy. Mr. Amash. Ms. Fox. Mr. Hurd. Mr. Mitchell. Mr. Clay. Mr. Gomez.
Yes, sir. He just responded to you.
The gentleman from Missouri. Gentleman from Missouri votes no.
Mr. Clay votes no.
The clerk will report. The clerk will suspend. The gentleman from Texas is recognized. Mr. Hurd of Texas votes aye.
Mr. Hurd votes aye.
The gentlewoman from North Carolina.
Mrs. Fox votes yes.
Clerk will report.
Mr. Chairman, 38 members voted aye, 31 members voted no.
And the motion to table the appeal of the ruling of the chair is upheld. The chair recognizes the gentleman from Maryland, Mr. Cummings, for his questions.
Mr. Strzok, first of all, let me say this, that to the members of the FBI who may be watching this, I want them to be clear that we have the utmost respect for the organization. And I thank them for doing what they do every day and protecting our rights and protecting our people and protecting our way of life. And as I listen to you in answering Chairman Gowdy's questions, particularly at the end, you gave a very impassioned statement, but can you understand why there are members that question whether the thoughts that you may have, that you put in an email or text, might interfere with the investigation? I mean, can you understand at least the questioning of that?
Yes, sir, I do.
And I want to, and I know you're familiar with oaths because I'm sure you've taken them 50 million times, but I remind you that you're under oath, and I'm just going to ask you this. How do you square that? In other words, I understand the piece about there's so many layers that the FBI wouldn't even allow to happen, even if you wanted them to. But how do you take that, compartmentalize, I guess that's the best word I can think of, and then when you walk into that room, be neutral or independent or live up to your oath? Do you understand my question?
I do, sir.
All right, can you answer that? Because I think that would be very helpful to me. And hopefully you are answering that question will be helpful to my colleagues. In fairness to all of us. Go ahead.
Yes, sir. Thank you. And I certainly do, sir, appreciate and understand that question and that concern, and why people would lick those texts and want to know why and how they should believe that those personal beliefs played any role in my official acts. What I can tell you, sir, is that first, I, like every FBI agent, like every person in this room, like everybody watching, has a political opinion. And each and every one of those people in the FBI, whatever their political beliefs, walks in the door and they leave those behind. The FBI has a culture. It is in our culture, it is in our training, it is in our policy, and everything we do is dedicated to the pursuit of the facts where they lay and applying the law to those facts. There is no room for personal belief. It is something that is anathema to us. It is simply official acts. What I can tell you, sir, is that first, I, like every FBI agent, like every person in this room, like everybody watching, has a political opinion. And each and every one of those people in the FBI, whatever their political beliefs, walks in the door, and they leave those behind. The FBI has a culture. It is in our culture, it is in our training, it is in our policy, and everything we do is dedicated to the pursuit of the facts where they lay and applying the law to those facts. There is no room for personal belief. It is something that is anathema to us. It is simply something culturally that doesn't occur, and were it to occur, it would be noted and stopped. And in addition to that culture, we have policies, we have procedures, we have laws, we have guidelines that are designed to provide outside checks and balances, to provide for outside review, to provide for any number of ways that the individual actions of any agent, any analyst, any support personnel are not acting in any way other than official policies and procedures. So when I tell you, again, as I did, personally what I believe and what I did, I understand why people may or may not have doubts or believe that, but then I would turn to you and say, look at the entirety of the rest of the organization, of the men and women who make it up, of all the things that are in place to ensure that our job in the FBI is to competently and independently pursue the facts wherever they are, and I cannot stress to you enough that is exactly what is done day in, day out, and that is exactly what has guided my behavior for over 26 years.
All right, thank you very much. Let me ask you this. In previous testimony to Congress, President Trump's FBI Director, Christopher Wray, explained the critical importance of protecting confidential human sources. And this is what he said, Agent Strzok, and I quote, "The day we can't protect human sources is the day the American people start becoming less safe," end of quote. Do you agree with that?
I do.
The problem is we now have the transcript of your 11-hour closed-door interview with our committees, and it shows that Republican members asked you repeatedly about confidential human sources involved in the Russia investigation. Is that correct?
My recollection is yes, sir.
Do you remember how many questions they asked you about that?
I do not, sir.
Let me read one of their questions from the transcript. One Republican member asked you this question, and I quote, "In the month of July, was there any information from confidential human sources given to you as it relates to the Russia investigation?" End of quote. Do you recall being asked that question?
I do.
That question was specifically about information from confidential human sources in the Russia investigation. Obviously, you could not answer the question, and that is because the Department of Justice has a long-standing policy against revealing information from confidential human sources during an ongoing criminal investigation. Is that right?
Yes, sir.
Will the gentleman yield?
I will yield if at the end I want to finish. And that is what Director Wray was talking about when he testified that revealing those sources or their information will make America less safe. Is that right?
I don't know why Director Wray said that, but I agree with his statement.
In your experience, how dangerous could it be to reveal the identity of a confidential human source?
Extraordinarily dangerous.
Will the gentleman yield to his friend?
Of course.
I thank the gentleman. I want to be clear, since the gentleman from Maryland, who is my friend, is going along a line of argument that would suggest a question asked by me. I want to make it perfectly clear. I ask if you talked with confidential human sources. I never asked for a name, nor would I ever ask for a name of a confidential human source. I appreciate it. I'll yield back.
Yeah, I don't think I said that. But anyway, thank you, gentlemen. Disclosing the identity of a confidential human source could create a risk to that person or our national security. Is that correct?
Yes.
What effect could revealing a confidential human source have on the FBI's ability to recruit or retain human sources in the future?
I think it could and is having an extraordinary impact in that people who come to the FBI with information are putting themselves at risk, anywhere from risk of their job, risk of their life, and they trust and put their literally and sometimes lives in the hands of the FBI. So when they observe if their identity is putting at risk, clearly that's a personal risk to that individual source. But every other potential source out there, every other person in Washington, D.C. or Beijing or Moscow wondering about approaching the FBI to give them information is going to look to how well or how poorly the FBI protects their information and protects their identity as they weigh whether or not to take that extraordinary risk to work with the FBI and to work with the United States of America.
Mr. Strzok, the Inspector General's report criticized your political text messages and raised concern that your political views may have impacted your decision in the summer and fall of 2016 to prioritize the Trump-Russia investigation over the reopening of the Clinton email investigation. I understand from your transcribed interview with the committee that you foreign power was seeking to clandestinely influence our presidential election. You remember saying that?
I do.
Why is the interference by a hostile foreign power in our presidential election such a monumental threat to our nation?
Well, I think when you look at the threat that represents, when you look at the threats facing the United States and what it means to protect the United States, the prospect of voting is the key core of who we are as a democracy. And there is no more important vote that we exercise as a people than the vote for the President of the United States. So when I look at the span of threats that I was responsible for,
and I quote, "I cannot think of a more grave allegation of the Counterintelligence Division, or let alone the nation, than that a hostile foreign power was seeking to clandestinely influence our presidential election." You remember saying that?
I do.
Why is the interference by a hostile foreign power in our presidential election such a monumental threat to our nation?
I think when you look at the threat that represents, when you look at the threats facing the United States and what it means to protect the United States, the prospect of voting is the key core of who we are as a democracy. And there is no more important vote that we exercise as a people than the vote for the President of the United States. So when I look at the span of threats that I was responsible for, that the Counterintelligence Division was responsible for, and the FBI, the prospect of a hostile foreign power interfering and influencing the election for the President of the United States of America, I can think of few more severe or consequential threats facing our nation than that one.
And just two more questions. What could be the potential impact of a hostile foreign power successfully interfering with our presidential election?
Well, I think it's multifold. I think there is certainly, from a broad perspective, it draws into question the effectiveness and the credibility of our electoral system. It places into question the motivations and the actions of those people, either who are elected or who were brought in as staff to staff that campaign and eventually administration. I think it draws into question whether or not the actions of the elected party and group of governing folks are acting ultimately in the interest of the United States, or whether or not there's the potential that those interests have been compromised in favor of that foreign power.
And finally, how is that threat made worse if the presidential campaign colluded or worked with the hostile foreign power?
I think that would be the worst realization of that potential threat. I think it would indicate the FBI, some of that's a hypothetical. I think the FBI would approach that from the perspective that if there were people within the campaign who are colluding or working with the government of Russia, that there is very little that would be of more importance to the FBI or actually the expectation of the American people that we get to the bottom of it. The American people, I think, expect that. Frankly, any presidential candidate who might have that going on in their campaign, I think, would want to know about that and have the FBI get to the bottom of it. But any actual collusion or cooperation would be amongst the gravest threats to our democracy.
Chairman, are you back?
Chair, thanks, gentleman. Recognize himself. Ms. Strzok, I want to follow up on a couple of the questions Chairman Gowdy asked. Your texts and emails make it appear you'd come to a conclusion on the Clinton case long before you had interviewed many witnesses, including Clinton herself. You also appear to have been pining for the impeachment of President Trump at the very beginnings of the Russia case. Does the FBI normally make such decisions on whether to recommend prosecution or exoneration so far ahead of all the facts coming to light?
Typically, sir, DOJ makes prosecution decisions in cases.
Do they normally make such decisions and whether to recommend prosecution far ahead of the facts coming to light?
Sir, I don't think any decision, in my experience, the final decision is never made until the conclusion of the case. I think it is fair to say that in the conduct of investigations, particularly very large investigations with a lot of folks working on it, my experience is there comes a time, if you're worth your salt in the conduct of that investigation, an agent, the attorneys assigned to that will have a very good idea well before the case is concluded that there may or may not be demonstrable crimes, that there may
Let me ask you this then. How many other cases on which you have worked do you recall opining on the disposition of the case months ahead of interviewing multiple witnesses?
I remember quite a few cases where I or agents would discuss the prospects of the outcome of the case with prosecutors as the case was going on, from the beginning of the case, talking about what crimes may or may not be relevant, as the case proceeded to identify which elements may or may not be strong or demonstrable, as well as towards the end when we were trying to shore up evidence that may or may not be there. But
and let me ask you this about that. In regard to those cases, was it normal behavior on your part to chat with colleagues in the manner you did on the Russia case about how much you despise the very person you're investigating, or complimenting the person you're investigating in the Clinton case? Is that typical?
Sir, I would draw a distinction between commenting on case-related matters versus discussion of personal belief. I think those are very different matters than saying this person as a witness was not credible, or this person as a target or a subject did or didn't do something. That is a very different matter.
So you could completely separate out what your personal opinion is from what you discussed with others in investigations.
I'm telling you, sir, I separated out my personal belief from any
But you did not do that with regard to Attorney Page, who was also involved in these investigations.
Sir, I disagree with that. I separated out my personal beliefs from any action I took officially as an FBI agent every day.
Do you recognize how your vitriol against President Trump makes it appear you could never approach the case in a fair-minded manner?
Sir, of course I appreciate that. I understand.
So let's discuss
look at
a text that hits home for me. On August 26, 2016, you texted Ms. Page, quote, "Just went to a Southern Virginia Walmart. I could smell the Trump support." And smell is in capital letters, all capital letters. What does Trump support smell like, Mr. Strzok?
Sir, that's an expression of speech. I clearly wasn't smelling one thing or the other. What I was commenting on is living in Northern Virginia.
What does that mean?
What I meant by that was living in Northern Virginia, having traveled 100 and 150 miles south within the same state, I was struck by the extraordinary difference in the expression of political opinion and belief amongst the community there.
And you described that as smell in capital letters.
Sir, that was a quick choice of words in a text.
All right, so earlier,
seen or heard.
Okay, so earlier you had texted Ms. Page on that another part of Virginia, Loudoun County, which is, I think, in Northern Virginia, is, quote, still ignorant hillbillies, end quote. Is that what you meant?
No, sir, not at all.
That you consider Trump supporters to be ignorant hillbillies?
Not at all.
What did you mean by that?
Well, sir, the first thing I'd tell you is, as a proud Fairfax County resident, there's a healthy sort of competition between Fairfax and Loudoun. Second thing I would tell you is that in no way did I or do I believe any resident of Loudoun County or Southern Virginia or anywhere else in the nation are any of those things. That was a flippant text.
So do you understand the implications of this text when my constituents in Virginia read it?
I do, sir, and I would ask you to tell them that that was a, in some cases, certainly unfortunate use of words, that in no way do I believe that those things are what.
Now, you and Ms. Page used personal phones and accounts to communicate. Have you turned over those communications to the Inspector General?
No, sir.
If not, why not?
Sir, they asked, and working with my attorney, the Inspector General and I arranged an agreement where I would go through my personal accounts and identify any material that was relevant to FBI business and turn it over. It was reviewed. There was none, and my understanding is the Inspector General was satisfied with that action.
We know from text that you and Ms. Page would transition to iMessage and Gmail. Who determined that messages were only personal in nature and not business related, especially since you've just testified at length that a number of the communications that you have made on government communications devices were personal in nature?
Sir, the broad context of what I used personal email and phones for was personal communication. For those things that were work-related, almost universally that material was translated into FBI systems. Certainly if it was anything that was a record or would constitute needing to be there, it was provided, but I made that decision.
So let me ask you this. When did Attorney General Lynch know that charges would not be brought against former Secretary of State Clinton?
I can't answer that question, sir. That's something you'd have to ask her.
Do you know whether it was prior to Lynch's announcement that she would defer to career prosecutors and Director Comey on whether to prosecute?
Sir, I don't know.
Clinton. Why would Lisa Page text that Lynch's decision was a, quote, real profile in courage since she knows no charges will be brought, end quote?
So that's a question you have to ask her.
So how did you take that statement when she texted it to you?
The way I took that, sir, is that we had for many months working with a team of career attorneys in the Department of Justice, a team of attorneys from the Eastern District of Virginia, a team of agents from the FBI. I've been working intensively on this case. We had gone through mountains of evidence, tons of interviews, and we were looking at the various statutes that might apply to any sort of criminal conduct. And I think we were, as we surveyed that, as the attorneys looked at it, saw a number of very fatal areas where elements of the crime were lacking, our ability to demonstrate facts to prove those elements of a crime. So I think we had begun to arrive at a sense that it was going to be difficult, if not impossible, to identify any statute where we could satisfy those elements of the crime. My assumption certainly is that from the Department of Justice's perspective, those line attorneys were briefing their supervisors, who were briefing their supervisors, who were ultimately briefing the Deputy Attorney General and the Attorney General, and that she would have that same sense that it was a difficult, if not impossible, proposition to conclude that there were viable charges to be brought against Secretary Clinton.
Mr. Strzok, did you ever believe these texts would become public?
I did not.
Given that, you felt free to express your true feelings, didn't you?
I suppose, yes. That's a difficult question to answer.
Mr. Strzok, former Director Comey played judge, jury, and exonerator in the Hillary Clinton investigation. In your experience at the FBI, have you ever seen the FBI director make the decision on whether to prosecute for the Department of Justice?
Mr. Chairman, I would not agree with that characterization of Director Comey, and in answer to your question, I have not seen it before.
All right. Was that appropriate, what he did, to hold a news conference and publicly announce the decision that was supposed to have been made by the Department of Justice?
Sir, that was his decision.
Was it appropriate, in your opinion?
Sir, I don't think it's for me to say whether or not.
I think it is for you to say. I asked you the question. What's your opinion?
Sir, I understand the variety of factors that went into, well, I understand some of the factors that went into Director Comey's decision to make the announcement. I can tell you that that decision was not made lightly at all. I can tell you my experience in that decision.
But you're not aware of any precedent for that?
I'm not.
Mr. Strzok, in a footnote 197 of the Inspector General's report, it is noted that, quote, supervision of the Russia investigation was briefly transitioned from Strzok to another counterintelligence division, DAD, in early 2017. Why were you transitioned from the Russia investigation in early 2017?
Sir, let me see if I can answer that question without getting into operational detail. The investigation was broad. What Russia was doing against our country encompassed a variety of things. There were actions in the cyber arena. There were actions by their agents and their intelligence services. There were actions by subjects of investigation that are currently ongoing. The prospect of how the FBI would investigate that was a multi-tiered effort. And so some of those efforts that traditionally fell into line with that other DAD and their span and scope of responsibility were moved to their supervision.
So the footnote goes on to state that, quote, however, AD Priestap told us that FBI leadership decided to keep Strzok involved in the Russia investigation, and he was therefore reassigned back to it. Do you know who in, quote, FBI leadership, end quote, decided to keep you involved in the Russia investigation?
I do not.
Could it have been Deputy Director McCabe?
Sir, possibly I do not know.
And when were you assigned back to the Russia investigation? And when you were reassigned back to the Russia investigation, were you still in a supervisory role?
Sir, I would answer that question again. I don't entirely, my recollection does not comport with the statement from AD Priestap. There were elements of the investigation that stayed under subordinate leaders and subordinate section chiefs and unit chiefs on down the line. There were elements of it that were transferred to a different DAD and remained with that DAD. So my recollection is a bit different from AD Priestap's.
Mr. Strzok, did you ever consider recusing yourself since you had such personal disdain for the person you were investigating?
I did not.
Yet others did require that ultimately.
Sir, I would not characterize those decisions as subject to the same set of considerations.
You don't think that it was the bias expressed in your text messages that caused Mr. Mueller to remove you from the investigation?
I do not think that that bias was expressed in those text messages. I cannot speak to why Director Mueller chose to remove me from the investigation, but I can tell you that those text messages are not indicative of bias.
Mr. Mueller never told you why you were being removed?
My recollection of the discussion was he mentioned the existence of the text messages, and that based on that, he needed to ask me to return to the FBI.
Lots of people have text messages, Mr. Strzok.
Yes, sir. And again, my impression, not stated by him, but my impression was that based on the appearance of those messages and in part of a desire by him to avoid even the appearance of any potential bias, that he asked me to return. But that's a question for him.
But he kept everyone else.
Sir, I don't know the staffing decisions that were made by Director Mueller after I departed.
Including 13 Democrats.
Sir, I don't know the affiliation of the people on his team.
So, but he was concerned enough about your text to remove you, but you never felt concerned enough to remove yourself.
That's correct.
Mr. Strzok, you're going to get asked other questions here that relate to your transition from the investigation of Ms. Clinton into the beginnings of this investigation into the Trump campaign and the alleged collusion with the Russian government. Now, Mr. Strzok, the FBI is a creation of this body. Congress created the FBI with its constitutional authority. Today, you are here under subpoena. I know you've come voluntarily in your opinion, but you're also under subpoena, also an exercise of Congress's constitutional authority. Which takes precedence, FBI policy or the United States Constitution?
Sir, always the United States Constitution. My understanding is I am not here under subpoena, that I am here voluntarily. I understand a subpoena was issued for my prior closed interview, but not for this session today.
A subpoena was issued and service of which was accepted.
That's not my understanding, sir.
In a Supreme Court case handed down just last year, The court reviewed whether statements made by a juror that indicated racial bias required the piercing of jury deliberations. Justice Kennedy wrote the opinion of the court holding that racial bias exhibited by a juror provided an exception to the rule that jury deliberations must remain confidential because it is necessary, quote, to ensure that our legal system remains capable of coming ever closer to the promise of equal treatment under the law that is so central to a functioning democracy. On several occasions, you have referenced that all the texts in the questions were simply personal opinions exchanged with a close confidant and in no way reflected your intent to act on your opinions. Yet, if you made these statements while on a jury, it is hard to imagine that you would not be kicked off immediately because of the risk that your bias would undermine a functioning democracy. Do you still hold that personal opinions, even in the face of Supreme Court precedent, should not have tainted your involvement on any investigation relating to Secretary Clinton or President Trump?
Mr. Chairman, I think you're mixing apples and oranges. I'm not an attorney, and I'm not familiar with that Supreme Court ruling. But based on what you said, protected categories, things like race, gender, ethnicity, sexual orientation, religion, are protected matters that we may not, the government and by law, people may not be discriminated against based on their role one way or the other in any one of those categories. That is entirely separate and distinct from political belief or political opinion. That, on the other hand, is encouraged, is protected by the First Amendment. And this body, under the Hatch Act, my understanding is, sat and said and recognized—
No one stopped you from sending the text, Mr. Strzok, but the special counsel, Mr. Mueller, removed you from the investigation when he saw the texts.
That's true, sir, he did. Now, if I may go back to answering your question, if I may. In terms of political speech, that is radically different from any sort of protected category of race, gender, and ethnicity or other categories. Political speech, political thought is protected. The courts have recognized, the Constitution recognizes we all have political belief. And so when it comes to the expression of that political belief, that is something that this body, under the Hatch Act, enumerated kind of the categories of what was prohibited, and then expressly stated that if it is not prohibited, then it is expressly encouraged. So I would tell you that no one in here, it's an impossible definition to say people must not have political opinion. Everyone does. Of course they do. The test is whether or not that is left behind when you're doing your job. To your question of whether or not I would express that in front of a jury, of course I wouldn't. That would be inappropriate. As to your question of whether each and every one of those jurors, when they go home and they're sitting in their backyard with a friend, has a political opinion, my answer would be undoubtedly, almost if not all of those jurors would.
But they're instructed when they leave the jury panel each day to not communicate with anyone regarding the matter that they are considering. So that is a very different thing. You were considering a matter and you were conducting texts of a very biased, salacious manner that was totally inappropriate. And when Mr. Mueller saw that, he removed you.
Sir, I appreciate that concern. But what I'm telling you is there is a vast difference in my mind between an action as a juror being instructed by a judge not to discuss the matters of a trial compared to a citizen of the United States.
You don't suppose there's a reason why
discussing his personal
You don't suppose there's a reason why that instruction made? So the chair recognizes the gentleman from New York, Mr. Nadler.
Thank you. Let me begin by congratulating the witness on his completely correct statement of key First Amendment law, that people are entitled to political opinions. Now, you, sir, obviously expressed your political opinions as to Mr. Trump and Hillary Clinton and various others in text messages to Lisa Page.
I did.
And she to you.
Yes.
And these were private political opinions.
Yes.
Which you did not express publicly.
Correct.
And the Inspector General found, with respect to the investigation to Hillary, quote, "We found no evidence that the conclusions by the prosecutors were affected by bias or other improper considerations. Rather, we determined that they were based on the prosecutor's assessment of the facts, the law, and past department practices." That is correct, that is the finding of the IG, no?
Yes, sir.
Thank you. And with respect to the Russia investigation, the IG said that that he was disturbed by the appearance that investigative decisions might be impacted by bias, but made no such findings and, in fact, hadn't completed his investigation of the Russia investigation. Is that correct?
Yes, sir.
Now, when people talk about the appearance, whether people on this panel or the Inspector General, the appearance of bias created by those text messages might create the appearance of bias only if they're public. Is that not correct?
That's correct.
Because otherwise there'd be no appearance.
That's correct.
And they were not intended to be public, were they?
Correct.
They were communications between two private individuals.
True.
Which are totally permitted.
That's correct.
Now, are FBI agents permitted to have political opinions?
Yes.
And as a 22-year veteran of the FBI, could you tell us, without naming names, were you familiar with the fact, with other FBI personnel having political opinions with respect to the presidential campaign?
I was.
And were some of these people anti-Trump?
They were.
And were some of these people pro-Trump?
Yes.
Thank you. And to your knowledge, did any of the pro-Trump bias or the anti-Trump bias in personal opinions affect decisions and investigations by the FBI?
Not to my knowledge.
Okay. Now, you mentioned the Hatch Act.
Yes.
Under the Hatch Act, the FBI is prohibited, is it not, from inquiring as to the political opinions of people it is hiring?
I don't know the Hatch Act well enough to tell you.
Well, I'll say that that is the case. The government may not, under the Hatch Act, inquire as to the political opinions of people it is hiring for non-exempt positions. And to do so would be improper. And I must say that I think that all of these inquiries about your political opinions as revealed by these text messages are irrelevant and wrong unless it can be shown, as it has not been shown, as was found definitively not to be the case in the Hillary investigation and has not been shown in the Russia investigation, that they affected any decisions in the investigation. Let's leave it at that on that point. Now, Mr. Strzok, what is the FBI's policy? Oh, and let me say one other thing. It is prudent, and I'll observe this because you said you couldn't answer, but it's obviously prudent of Mr. Mueller in finding these texts and hearing about all these text messages to think that they might be subject to incorrect interpretations on publicity, and in order to avoid the kind of attacks on this investigation that we are seeing from Republican members of this committee and from the administration, to ask you to leave that investigation having nothing to do with your competence or fairness in the investigation, but simply to somewhat insulate that investigation from unfair attacks. Would you think that that might be a correct?
Yes.
Thank you. Now, Mr. Strzok, what is the FBI's policy with respect to its agents commenting publicly about an ongoing criminal investigation?
We don't do that.
Sorry?
We do not do that.
And why is that policy in place?
I think for a variety of reasons. One, I think it is inherently unfair to the subject of that investigation. It can tend to skew the conduct of that investigation, other witnesses, other future investigative avenues. It can skew potential jurors in the event that a case is taken to prosecution. I can think of any number of reasons why we don't do that.
And are you thank you. Are you familiar with the Inspector General's report on the FBI's handling of the Clinton investigation?
I am.
And that report was highly critical of Director Comey, was it not, for, among other things, departing from protocol and commenting publicly about an ongoing criminal investigation.
It did say that, yes.
It was critical of him.
Yes.
And for doing that. And although some people have said that they don't agree with the decision not to charge Mrs. Clinton, in fact, the departure from protocol was the first departure from protocol, I should say, was Director Comey's commenting on on his opinion about her handling of various emails and so forth, having decided after she wasn't being charged, his departing from protocol was publicly commenting about that. Was that not one of the deviations from protocol cited by the report?
By the report, yes, sir.
Thank you. Has the FBI asked you to adhere to that policy of not commenting on ongoing criminal investigations, namely the Russia investigation, for example, today?
Yes.
How so?
They instructed me. My understanding is that General Counsel for the FBI met with Chairman Goodlatte and his staff and came up with an approved list of topics that I might speak about, and that outside of that list, that I was not to discuss anything having to do with ongoing investigations.
Thank you. And I will simply observe that asking you or anybody else, like Mr. Rosenstein, to comment on ongoing criminal investigations is against policy and is liable to taint those investigations and to damage the reputations of people or to even endanger the safety of informants, as you have said. Mr. Strzok, you're an experienced counterintelligence official. Can you explain why, briefly, because I think you touched on this in Mr. Cummings' questions, why the investigation to the Russian government's attack on our elections and other critical infrastructure is important to our national security?
I think it's extraordinarily important because of what it represents. The selection of our nation's leader, of the chief executive, of the person who is charged with the defense of the United States and national security of the United States, whether that's militarily or economic, there is no greater responsibility in the land. And the way we do that, the underpinning of what we are in America, the election, is the process by which we do that. So the idea that not only a foreign nation, but an advanced, hostile foreign nation would be inserting themselves clandestinely in that process to undermine the will of the United States people is terrible.
Thank you. And is that why you thought it important to prioritize and I think it was in October of 2016, the Russian investigation, and leave Mr. Weiner's laptop to someone else you asked to look into it?
Well, the first reason I did it is because the director told me to. The director said it was our top priority, which was relayed from him and AD Priestep. And the second thing was, yes, clearly when you look at an allocation of resources based on the threat to national security, the Russian influence investigations were a much greater impact than a mishandling of classified information investigation.
Thank you. But the first reason was the director told you to.
Yes, sir.
Thank you. How frequently does the FBI engage in counterintelligence operations against foreign powers?
Every day.
All the time?
Yes, sir.
And how frequently does the FBI investigate a possible conspiracy between a presidential candidate or campaign and a hostile foreign power?
This is the first one I can remember in my lifetime.
So is it fair to say that we are in unprecedented territory? Still facing a grave threat from a hostile foreign power?
It is.
Thank you. I think that is correct, Mr. Strzok. We know that Russia, after successfully interfering with our last elections, is actively working to disrupt the upcoming elections in 2018. We are told this by all of our intelligence agencies, all of whom still stand by their 2017 assessment that the Russian government waged a complex campaign to influence the 2016 election to the benefit of President Trump. Last week, the Senate Intelligence Committee, on a bipartisan basis, confirmed this assessment. And the Director of National Intelligence testified before the Senate Intelligence Committee about an even more urgent threat. Quote, there should be no doubt that Russia perceived that its past efforts as successful and views the 2018 U.S. midterm elections as a potential target for Russian midterm operations, close quote. And what is the majority's response to this problem? To launch an investigation into Hillary Clinton's emails and to do as much as they can to undermine Special Counsel Robert Mueller, who is running what is perhaps the most consequential national security investigation of this generation. When they aren't bullying you and Ms. Page, Mr. Strzok, the Republicans are usually taking aim at Deputy Attorney General Rod Rosenstein. And just as they insist on asking you questions about an ongoing investigation, questions you cannot answer, the majority insists on demanding some of the most sensitive information in the Deputy Attorney General's possession, documents he cannot provide for the same reason. They want copies, for example, of the scoping documents that lay out the special counsel's exact lines of inquiry. Such a disclosure would be dangerous and unprecedented. Republicans are in effect demanding that DOJ violate the very policies the Inspector General criticized the department for violating in 2016. This is incredibly inappropriate and dangerous, and we are forced to ask ourselves, why? Why have House Republicans been so dismissive of Russia's attacks on the United States? Why are Republicans so intent on destroying public confidence in the Justice Department and in the special counsel's investigation? Why have they abandoned House rules to pick totally unnecessary fights with you, Mr. Strzok, with Lisa Page, and with Deputy Attorney General Rosenstein? The obvious answer is because they are scared. Because President Trump is scared. Because the special counsel's investigation is operating at a breakneck pace and has already produced 5 guilty pleas and criminal charges against 23 individuals and entities. Because accountability is coming one way or another, and they are scared and they are trying to undermine the investigation and to distract attention. Now, I must say the basis of many of these questions that we are hearing today of Mr. Strzok by the majority, by the Republicans, is the 11-hour interview with Mr. Strzok. And I now call upon the majority to release that transcript in full today. This will show that this is the entire joint investigation is at best a partisan distraction from more important matters. But the witness before us today, Mr. Strzok, testified not under confidentiality, but not under confidentiality rules, but in private for 11 hours. There is nothing that prevents the majority from releasing that transcript. Selective portions of that transcript have been leaked by members of the majority, misleading portions in taken out. We're not releasing transcripts, except parts of them that may convey the impression, false or true, that we want to convey. There is no legal reason why this transcript should not be released. There is only a partisan reason why this transcript should not be released. There is no valid reason why it should not be released. If there was a purpose to our inquiries, to our spending 11 hours, there's no reason they shouldn't be released. I'll yield now.
I thank the gentleman for yielding, and I would just say that it is very customary in investigations to keep transcripts of private interviews until the conclusion of the investigation. This investigation certainly hasn't concluded, and it is very appropriate that the questions that were asked and the answers given are not shared with other potential witnesses.
Reclaiming my time, I will observe that many of the same questions are being asked today, number one, but number two, given the fact that selective portions of the transcript have been leaked, I think that changes that. I'll yield to Mr. Cicilline.
I was just going to inquire. I've sort of been trying to get the answer to this question, but to the extent that this transcript is available to all of us, I intend to release it. I can't find any prohibition that makes us unable to release it in our rules. We now have the same witness after 11 hours here in a public hearing, so the notion that we have to somehow keep this secret while pieces that are being released is doing a real disservice to the American people, and I'm asking the ranking member, is there any reason this afternoon I can't just release it as a member of this committee?
Would the ranking member yield?
Let me, 1 second. I'm not aware of any, but I have to look at the House rules and all. I will yield.
I thank the gentleman for yielding. It is correct that both members on the Republican side and the Democratic side have used quotations from the transcript for the purpose of interviewing a hearing, and that is a legitimate use of the transcript.
And I'm reclaiming my time. Some members have also used it for the purpose of talking to the news media, and that may be or may not be an appropriate use. But be that as it may, the transcript should be released. I'll yield back.
Gentleman yield.
Yes, I'll yield to the gentleman from Maryland.
I'd like to ask the ranking member if it's legitimate within the rules of the committee in the House of Representatives for members to release certain portions of the overall transcript. Is there anything that would prevent us from releasing the entire transcript?
I'm unaware of anything that would, off the top of my head, that would prevent a member from releasing the transcript, but that's off the top of my head. I wouldn't want to say that definitively.
Mr. Chairman, are you aware of anything that would preclude us from doing that?
Yeah, the decision is made by the chairman of the committee.
Before I yield back, let me just say, we don't want portions released.
I'm not in the practice of having the chairman of the committee make decisions for me. So could you explain to me, is there a rule that precludes me from this afternoon releasing this transcript? If it's just your preference, that's not sufficient.
This is a conduct of an investigation. The chair of the two committees are conducting that investigation. We will decide when transcripts of private interviews are going to be released. No one on this side of the aisle has released it other than to ask a question based upon it in a hearing, which is an appropriate use of it.
Reclaiming my time.
We could release it as part of this hearing.
Reclaiming my time, I will observe that some members have released parts of the transcript by being quoted in the media, not for questions here. Does the gentleman from Rhode Island still want Time.
I just have a unanimous consent request. I'd ask unanimous consent that the transcript of this witness be made an official part of this record in its entirety.
I object.
Objection is heard.
Well, I'm not aware, the gentleman from...
Roll call vote.
I thank the gentleman for yielding. Again, Mr. Chairman, I think this is of tremendous interest to the American people. There's an effort here to sort of characterize this witness's behavior. Much ado has been made of it. We had an 11-hour hearing in which this very same witness testified. He's now testifying consistently before the American people. There seems to me, no good reason, other than a personal preference of some apparently, that this transcript not be released. And I would say to the chairman respectfully, if there is no prohibition, the fact that you would prefer we not is insufficient to persuade me, and I think Mr. Raskin, and we intend to release this transcript unless someone presents us with some rule under our House proceedings or this committee that prevents us from doing it. And we'll give you till 5 o'clock this afternoon to present that. Otherwise, we intend to release the transcript.
Reclaiming my time, I'll simply, I want to associate myself with the remarks of the gentleman from Rhode Island. I would agree with him. I think it would be a public service to release these transcripts. That's why I demanded they be released. There's no good reason not to. And at this point, I think I'll yield back the balance of my time.
The chair wants to respond to the gentleman from Rhode Island. First of all,
yield back the balance of my time.
First of all, there was an agreement in the interview that it was private, confidential, and that it would not be released. So that is not going to take place under this set of circumstances. Secondly, if the gentleman, we're here investigating irregularities conducted in investigations by the FBI. If the gentleman wants to perpetuate that by creating irregularities here and releasing questions so that other potential future witnesses can read the question before they're asked, that is, in my opinion, exactly what many on the gentleman's side of the aisle have been all about, attempting to disrupt this investigation and this hearing process from start to finish.
Reclaiming my time, Mr. Strzok.
Would the gentleman yield?
Reclaiming my time.
Mr. Chairman, I object.
Mr. Strzok, would you object to the release of the transcript of that hearing?
No, I would not object.
Thank you. I will observe then that the minority, the chairman says that there was an agreement not, on the conduct of that hearing. The minority was not party to that agreement. There may have been an agreement between Mr. Gowdy and Mr. Goodlatte, but at no point were we asked.
It was stated on the record in the hearing.
No, it was stated as a decision, as a fact, as a fait accompli. We were not asked. We agreed to nothing because we were not asked. And we think that the transcript ought to be released for the reasons stated. And if the witness doesn't object, I don't know why the majority should object. And I yield to Mr. Meadows.
If the gentleman will yield, in earnest, I will be glad to work with my colleagues on the other side of the aisle about releasing all relevant information. I mean, I think if we're talking about full transparency, let's talk about full transparency in a variety of other things. It's interesting we want to release one thing, but yet we're somehow allowing Peter Strzok to suggest that there's a whole lot of things that are off the record. And so, but I will work in earnest with my colleagues.
I appreciate the gentleman, and let me simply say that we are not disrupting a legitimate investigation into the investigation. The Republican investigation is intended to and is trying to disrupt the investigation into the Russian interference in our election by the special counsel.
Would the gentleman
That's
yield?
what's really at stake. I yield back.
The gentleman yields back. All right. So now that the chairman and the ranking member have had ample time to ask questions, and I think that the gentleman from New York has the record, we are going to move, because we have 72 more members who have questions to ask, to strict adherence to the 5-minute rule, and we'll begin by recognizing the gentleman from Wisconsin, Mr. Sensenbrenner, for 5 minutes.
Thank you very much, Mr. Chairman. Let me observe that
You know, there have been all kinds of complaints about leaking transcripts and things like that. One of the reasons we are here today is because there has been a flood of leaks out of the Justice Department about what is going on. It's barely a day goes by when you can't pick up the newspaper and find out that it's rumored this and rumored that. And then we have a witness from the FBI that comes up here and says, oh, no, we can't talk about that here to the Congress, which has constitutional oversight responsibility because it's against our rules. Well, I hope there'd be a few prosecutions of people out of justice that have been leaking this stuff to the various news media. Now, I want to get to looking at statutes. You know, you look at rules, I've been looking at statutes. And somehow along the line, in the report on the conclusions of the Clinton investigation, the word gross negligence was changed to extremely careless in determining Mrs. Clinton's handling of classified information. Now, gross negligence would mean that it would subject her to criminal liability. Extremely careless would have the opposite effect. It would not. So I'd like to ask you, Mr. Strzok, a couple questions about that. In the original May 2nd draft of the statement that Director Comey was making, he characterized Mrs. Clinton's actions as grossly negligent. Is that correct?
That's my recollection, yes.
Yes. And are you aware that gross negligence was changed to extremely careless in the eventual statement?
Yes.
You know, you look at rules, I've been looking at statutes. And somehow along the line, in the report on the conclusions of the Clinton investigation, the word gross negligence was changed to extremely careless in determining Mrs. Clinton's handling of classified information. Now, gross negligence would mean that it would subject her to criminal liability. Extremely careless would have the opposite effect. It would not. So I'd like to ask you, Mr. Strzok, a couple questions about that. In the original May 2nd draft of the statement that Director Comey was making, he characterized Mrs. Clinton's actions as grossly negligent. Is that correct?
That's my recollection, yes.
Yes. And are you aware that gross negligence was changed to extremely careless in the eventual statement?
Yes.
Okay. Now, do you recall at the June 6, 2016 meeting attended by you and Mr. Rybicki, Ms. Moyer, Mr. Maffa, and Lisa Page to discuss the language of the statute on whether to use grossly negligent or something else in the draft statement? What was discussed at that meeting?
So, sir, I don't remember that specific meeting. There are a variety of meetings with a bunch of people that included discussion of this concern.
Okay. Did the alternative phrase extremely careless come up at the meeting?
It did at some point, sir. I don't know if it was during that meeting or at another one. I don't remember that.
Whenever it happened, who brought it up?
My recollection, sir, is that somebody within our Office of General Counsel did. It was one of the attorneys. I don't remember which one.
You don't remember who did?
No, it was a legal issue that one of the attorneys brought up.
Okay. Now, immediately after that meeting, metadata shows that you modified the draft statement on June 6th. Is this when the phrase grossly negligent was changed to extremely careless?
Sir, again, I don't recall specifically when it happened. I am aware as well of that metadata. My recollection is of working on the draft with a group of us in my office, because it was the largest office, and taking the inputs of probably 5 different people. And it was made there.
Was it your computer that put the change into the statement?
Based on my subsequent review of that metadata, I believe that to be true.
Okay, and who has access to your computer? Anybody beside you?
No, I do. My secretary had access to elements of it, but.
And why was the change made? You know, you were in the meeting where it was agreed that the change would be made. Why was that?
My recollection, sir, again, was this was, and I'm not an attorney, my recollection was that attorneys within the FBI had raised the concern that the use of gross negligence triggered a very specific legal meaning. In a legal context.
Yeah, criminal.
In a legal,
criminal.
That's exactly right. In a legal context, grossly negligent is used in various statutes to, particularly one of the mishandling statutes in 793, to talk about a criminal element of the criminal offense.
Okay.
And so, sir, if I may quickly, and I promise I'll
Well,
take
so
your time.
let
So
me
one of
say
the-
this change was Hillary's get out of jail free card, right?
Absolutely not, sir.
Well,
Not in any way.
Hillary hasn't been prosecuted, so if she wasn't grossly negligent but was extremely careless, then there's no criminal standard involved. With grossly negligent, there is.
Sir, I think there are a lot of things I would disagree with in that assertion. First is she received no get out of jail free card. We pursued the facts.
Well, she did get a get out of the White House free card when the voters cast their votes.
Sir, I've heard that said a lot, and I can tell you there's nothing further from the truth.
Oh,
there was an effort
Trump won. That's the truth.
So, sir, what I would tell you with regard to that decision, there was concern within the perspective of a legal definition of that term that people would draw an inference based on that use that it was necessarily talking about a particular subset of a statute. My understanding is
My time is just about up. That rates 4 Pinocchios. I yield back.
Sir, Mr. Chairman, may I respond?
The gentleman may respond.
Sir, what I would tell you with regard to that decision is that there was concern about the use of the word grossly negligent, and the question of whether or not Director Comey wanted to convey that in the sense of applying the elements of a crime, and that whether or not his use, when people heard that, particularly when lawyers looked at it, whether or not they would interpret that as his saying that she did or did not commit any particular statute. My recollection is that the lawyers, based on that, looking at the use of the word grossly negligent, looking at the way that's been defined, looking at the statute where it occurs, both realized that that was probably not what he wanted to say, and ultimately he made the decision to change that wording and convey what it was he did want to say, and that all of those discussions were generated based on a legal discussion of the use of that term as a legal definition, not as a indicia of violation of any particular statute at all.
The chair recognizes the gentlewoman from California, Ms. Lofgren, for 5 minutes.
Thank you, Mr. Strzok. I think it would be easier, going back to the last question, if you were simply able to indicate, to your knowledge, whether the evidence would have supported the use of gross negligence, and apparently the decision made by the lawyers in the FBI was that that was not the case, and therefore that term should not be used. I just want to talk at a more macro level about what's going on here. One of the things I try and do is to imagine how I would feel if various things had been done or said about a member of my own party who was president, and how I would react, because I think it's important to try and understand that. And when you take a look at the text that you sent, I think you've acknowledged that it would make people who were supporters of Trump uneasy about your intentions. And I think that was reflected in the Inspector General's report. And I think, obviously, that brought suspicion of you and the FBI among people who were Trump supporters. The fact that you also had highly critical texts of the Attorney General Eric Holder, of Governor Martin O'Malley, of Senator Bernie Sanders, isn't really relevant. They were not, to the best of my knowledge, subject to an investigation. And so, it was important that the Inspector General go in and take a look to find out for us, for this committee, and for the American people what really happened. And he did. He went in, he spent a lot of time, he interviewed many people, and here was his conclusion. He did chastise you, and I understand you accept that admonishment, but found that there was no evidence whatsoever of political bias in the decisions made in that investigation. And a direct quote, we did not find documentary or testimonial evidence that improper considerations were made. Now, to listen to some of my friends, you'd think that the FBI, which I had always felt was rather made up of the people who are in charge. You've got Mr. Wray, who was appointed by President Trump, who is not a Democrat, Mr. Comey, who was appointed by Mr. Trump. He's not a Democrat. I happen to know that Robert Mueller is not a Democrat. So these are not political decisions made by political operatives. They should be following the evidence. And I'd just like to note that if you had wanted to harm and interfere with the election of President Trump, you could have leaked information that the investigation was ongoing. But none of that came out. And as a matter of fact, we asked the leaders of the Department of Justice and FBI about whether there was an investigation of Mr. Trump prior to the election, and we were told they could not comment on it, which was in fact the appropriate response. You should not comment on an ongoing investigation. If you find something, you have an indictment. If you don't find something, you say nothing. That's where Mr. Comey erred. He violated that policy and he damaged the campaign of one of the candidates, and the rest is history. So I just think that this hearing, this extraordinary hearing, I've been here a member of Congress for 24 years. This is the first time we've had this kind of event, a circus really, of trying to really investigate the investigators when that's already done. I would urge that we make sure that the actions we take do not create further divisions in our country. You know, President Trump tweeted a few months ago, quote, "The top leadership and investigators of the FBI and the Justice Department have politicized the sacred investigative process in favor of Democrats and against Republicans, something which would have been unthinkable just a short time ago." Is that tweet supported by the Inspector General's report?
No.
Mr. Strzok? No, it is not. I would hope that those of us on the committee who believe in the rule of law, who understand that our country will be damaged if we allow political divisions to attack our law enforcement agencies, to undercut investigations, that we will be harming our country in a way that our enemies, including Russia, hope we would do. That's why they interfered in our election, to cause us harm, to create division among the American people and among us here in the halls of government. So I would ask that we take yes for an answer. The Inspector General did investigate this matter. He found out there wasn't political influence, and we wait for the results of Mr. Mueller's investigation. I pray that we find that our president was not involved. That would be great news for our country, and if that's Mr. Mueller's finding, I will accept it, not investigate it. I hope that we can put our partisanship at the door, step back from the precipice that we are finding ourselves now, and I would hope that this hearing, which I think serves no good purpose for our country, could be brought to an end. I yield back, Mr. Chairman.
Time, gentlewoman, has expired. The chair recognizes the gentleman from Tennessee, Mr. Duncan, for 5 minutes.
Thank you, Mr. Chairman. And first of all, very quickly, I would like to associate myself with the really outstanding opening statements made by Chairman Goodlatte and Chairman Gowdy, which I think were two of the finest opening statements I've heard in my 30 years in Congress, and express my views completely. Let me also say, while Mr. Strzok will stubbornly not admit what almost everyone else knows is extreme bias, I find it amazing that he can sit here and say that he was not biased in a way that clearly colored and affected his investigations. And if you don't agree with that, I want to read the words from Mr. Horowitz, the Inspector General of the Justice Department, who wrote that the Clinton investigation, quote, was the way it was conducted, quote, was inconsistent with typical investigative strategy and gave rise to accusations of bias and preferential treatment, unquote. Then I would guess that Mr. Strzok knows Chris Swecker, who spent 24 years with the FBI and retired as the head of all the FBI criminal investigations. And Mr. Swecker wrote, he said, the IG report presents jarring evidence of political bias by the FBI against Republican presidential candidate Donald Trump, but fails to add it all up to come to the inevitable conclusion that political bias was there. This is like saying 1 + 1 = 0. Mr. Strzok, do you have any reason to think that Mr. Horowitz or Mr. Swecker have some sort of bias or animosity toward you?
Sir, I disagree with Mr. Swecker's conclusions. I can't speak to Mr. Swecker's motivations of bias whatsoever, and I know of no bias by the Inspector General.
Also, Cheryl Atkinson, a columnist for one of the Capitol Hill newspapers, wrote this, quote, the earth-shattering finding on Strzok by the Inspector General confirms a citizenry's worst fears. A high-ranking government intel official allegedly conspired to affect the outcome of a U.S. presidential election. Let me ask you this, Mr. Strzok. You know that judges who have even minimal bias are required to recuse themselves from a case. Do you think that FBI agents have some sort of that they're special people who shouldn't be held the same high standards that judges are in deciding where to recuse themselves?
Sir, I would absolutely say that FBI agents, judges, all are expected that whatever their personal beliefs, that they set those beliefs aside in their pursuit of the truth or their application of the law.
So you don't believe that you were entitled to a lower standard
I believe
I
believe I'm held to the highest standard and that I abided by that.
But you told Chairman Goodlatte that you did not think you should have recused yourself in this case.
Sir, I'd say that's entirely consistent. I believe that all of my personal opinions were never taken into account in anything that I did in an official act. I think that was appropriate. I think that is in keeping with the highest standards of the FBI.
Well, I think that since both the Clinton and Trump investigations had and have such tremendous political ramifications, I think the ethical, fair, just, and proper thing would have been for you to recuse yourself and move on to other work. There were many other cases that you could have worked on that you had never expressed any bias, were there not? There were all kinds of cases.
Sir, I completely disagree with you. I don't think it would have been either necessary or required for me to recuse. I think every day with the Clinton investigation, with the Russian influence investigation, with the thousands of other investigations, and when I walked in the door, the entirety of my action was dedicated to pursuing the facts, wherever they lie.
You know that many times judges have defendants appear before them who, after they've been found guilty, they apologize, say they're sorry, but trying to get probation. And yet many times people think those apologies are said more in hopes of getting probation and in regret that they have been caught rather than in sincere apology. Do you feel that you should apologize in any way to the American people for the things that you have expressed, this extreme bias that you expressed? Do you have any regret as to calling Trump supporters saying that they smelled and things of that nature?
Sir, I think I expressed a couple of things. One, I don't agree with your characterization of my views as bias. I think what I clearly articulated, and I can understand those concerns, and I hope when you heard me in my opening statement, when I talked about my regret to the people, the harm and the hurt, to the people that I love and my family, when I talked to the way that these texts have been used against the FBI, when I responded to questions about using a turn of phrase about, smelling when I should have said hearing or seeing or whatever the case may be, that yes, those were not intended as direct animus towards any set of people. And I hope people understand that I do sincerely regret that. So I've said
the time of the gentleman has expired.
And I hope you hear that.
The chair recognizes the gentlewoman from New York, Ms. Maloney, for 5 minutes.
Thank you. Thank you, Mr. Strzok. For months, the Republicans have increasingly used their congressional oversight authority to undermine Special Counsel Mueller's investigation. They have even called for his investigation to be shut down. And why? It's concerning national security, and it seems to be successful. the special counsel has now obtained 5 guilty pleas and indicted 18 others. And included in these indictments and confessions and guilty pleas, Michael Flynn pled guilty to lying to the FBI. Rick Gates pled guilty to conspiring against our country. George Papadopoulos pled guilty to making false statements to our country and the FBI. So I'm not exactly sure what the Republicans want to shut down. Do they want to shut down the special counsel's upcoming trials against campaign manager Paul Manafort? One of these trials is scheduled to begin here in Virginia, in the Eastern District of Virginia, later this summer. And related to it, on February 22nd, a grand jury in Virginia approved a set of 32 counts of tax, financial, and bank fraud charges against Mr. Manafort. And on February 16th, a federal grand jury in the District of Columbia separately approved 5 other charges against Mr. Manafort and Mr. Gates, including, and I quote, conspiracy against the United States, end quote. And in this indictment that is coming forward, I'd like to quote from it. It says, the defendant, Paul Manafort, together with others, including Gates, knowingly and intentionally conspired to defraud the United States by impeding, impairing, obstruction, and defeating the lawful governmental functions of government agencies, namely the Department of Justice and the Department of the Treasury, and to commit offenses against the United States of America, end quote. Now, since this indictment, Gates has pleaded guilty, and he's now cooperating. And included in his statement of offense, quote, Manafort engaged in a variety of criminal schemes. And Gates, as part of that work for Manafort, knowingly and intentionally conspired to assist Manafort in criminal schemes, end quote. So I'd like to ask you, Mr. Strzok, to be clear, Mr. Gates is swearing under oath that he's in his guilty plea that he conspired with Mr. Manafort in criminal activity. Is that correct from what I'm reading?
Ma'am, I'm not familiar with this statement of facts, but I'll stipulate to what you're reading.
Okay. So in a few weeks, Mr. Manafort's trial date is set to begin, and the special counsel team of prosecutors will present their evidence. And I cannot imagine how anyone in this body or in this country, with the exception of Mr. Manafort and his co-conspirators, would ever want in any way, shape, or form to halt this trial from going forward. Can you think of any reason why anyone would want to halt this trial from going forward, Mr. Strzok?
I'm not aware of any.
Thank you, and I yield back.
Will the gentlewoman yield?
And I yield to Mr. Cummings. Yeah.
But the gentleman, I yield to the gentleman, Mr. Meadows.
I thank the gentleman, and I thank the gentlelady. Mr. Chairman, in a spirit of transparency, and I think we all want transparency here, I would offer for the chairman's consideration and this body's consideration, releasing the full transcripts that we had in the 11th hour, breaking with 2 different conditions. One is that we have the opportunity to interview Ms. Lisa Page first, since those text messages were back and forth between 2 witnesses. And the second, that we can scrub that transcribed interview for any personal relevant information that might be embarrassing before we do that. And with that, I'll yield back.
If the gentlewoman will yield.
Yes, I yield to the gentleman.
Thank you. The spirit of the gentleman's recommendation is taken, is well taken, and we will definitely take that under advisement.
The gentleman yield.
I yield.
I would also hope that we would give the FBI the opportunity for redaction of anything that would impact on the nation's national security. I think that is extremely important, and I hope the gentleman would accept my modification.
Reclaiming my time, it's my understanding the gentleman does accept that from the gentleman from North Carolina. And I want to thank him for trying to, as he usually does, trying to work these things out and full transparency. And I think that's important. I think the American people and this committee would appreciate it.
Will the gentleman yield for a question?
I yield.
Does the gentleman from North Carolina's suggestion relate solely to the testimony of Agent Strzok, or under the same guise of transparency, would we apply that same process and that same standard to the previously unreleased testimony of Andrew McCabe, who was examined in a similar environment?
I yield to the gentleman.
I think in a spirit of transparency, we need to look at all transcribed interviews to let the American people judge for themselves. I thank the gentleman for his question, and I think that's consistent with my conversation with the gentleman from Maryland.
Thank you very much, and I yield back.
The chair recognizes the gentleman from Texas, Mr. Smith, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I'll yield my time to my friend and colleague from Texas, Mr. Ratcliffe.
I thank my colleague for yielding. Agent Strzok, on May the 9th, 2017, President Trump fired FBI Director Jim Comey. That same day, you and FBI lawyer Lisa Page exchanged quite a few texts on the topic. At 8:14 p.m. on that day, you texted Ms. Page and said, quote, "And we need to open the case we've been waiting on now while Andy is acting," end quote. First, is that Andy McCabe, the former deputy director of the FBI, who has since been fired and criminally referred by the Inspector General?
It is.
All right. And what case are you referring to opening now that Andy is the acting director of the FBI?
Sir, to get into that would relate to ongoing investigations, which, consistent with the department's policy on ongoing investigations and based on the special counsel equities, I'm not authorized to discuss ongoing investigations.
Okay, well, let me see if I can give you a question that you can answer. You sent 4 more texts to Ms. Page, and her first response to you at the bottom of that page you're looking at is, quote, "We need to lock in," and then there's a black mark where someone's name's been redacted. "We need to lock in redacted in a formal, chargeable way, period. Soon, period." Whose name's been blacked out?
Sir, I don't know. I need to see the original list or original text.
You don't know? Okay. Well, I don't know either. Here's what else I don't know. I don't know if the person whose name has been redacted is Republican or Democrat. I don't know if they're black or brown or white.
I don't either, sir.
I don't know their religious beliefs. I don't know their sexual orientation. I don't know those things, and I don't care. But here's what I do know. I do know that decisions about when and whether to open investigations and when and whether to charge people with crimes aren't supposed to depend on who's sitting in the director's chair or on political decisions or on the political agendas of FBI agents and lawyers. So if a Trump-hating FBI agent and a Trump-hating FBI lawyer who have talked about effing Trump, stopping Trump, impeaching Trump, are within hours of President Trump firing their boss, if they start talking about opening an investigation now that Andy is acting and that some person needs to be locked in a formal, chargeable way soon, I know as a former U.S. attorney that if in fact that's what happened, I know that whoever is the subject of that case that was opened now that Andy is acting, and whoever you and Ms. Page talked about needing to be locked in soon in a formal, chargeable way, well, they would have had their civil liberties violated. They would have been deprived of due process. So my first question to you, you wouldn't answer. My second question to you, you couldn't answer. Let's go for a third question. On page 400 of the Inspector General report, someone tells the Inspector General, quote, "There is a bright line, a bright and inviolable line between what you think personally and belief and the conduct of your official business." Who said that?
I believe I did, sir.
You did say that. And I heard you say similar things last week. I heard you say similar things today. You said it very clearly. You said it very unequivocally in your opening remarks that you never crossed that inviolable line in 26 years. Earlier today, in response to a question, you said, "I took my personal belief out of every official action." So you're asking us to believe that when you say things like F Trump and stop Trump and impeach Trump, that those are just personal beliefs, and that when you say those things, you never cross that line, that bright, inviolable line and allow it to impact your official conduct. That's really what this comes down to, that you're asking us to believe, isn't it?
Sir, I'm asking you to believe, and I'm offering you evidence.
Yeah, well, you
whether
have.
It's the IG report, whether
made
it's
it crystal
anything that's
clear.
been found, that there's been no
Yeah.
active bias
Listen,
found anywhere.
You have under oath been as clear as a bell on that. You've said it over and over again. And because of that, I'm almost embarrassed to ask you this question. Of the approximately 50,000 text messages that I've seen with your personal beliefs like F Trump, stop Trump, impeach Trump, go ahead and confirm on the record that none of that occurred on an official FBI device or on official FBI time. Go ahead and do that.
Sir, no, they did. Many of them did occur.
Oh, they
And I
did.
would say
Okay,
of the
so
50,000, sir. the
So
majority,
really,
the
no, I'll
grand
give you a
majority of
chance at
those
the
were
end. So
work-related.
what you really meant to say was that when you said you never crossed that bright, inviolable line, what you meant to say was, except for 50,000 times, except for hundreds of times a day where I went back and forth, expressing my personal opinions about effing Trump and stopping Trump and impeaching Trump on official FBI phones, on official FBI time. Other than that, you never crossed that line. I'm sure there are 13,000 FBI agents out there that are beaming with pride at how clearly you've drawn that line. Agent Strzok, are you starting to understand why some folks out there don't believe a word you say, and why it's especially troubling that you, of all people, are at the center of the 3 highest profile investigations in recent times that involve President Trump, and that you were in charge of an investigation investigating, gathering evidence against Donald Trump, a subject that you hated, that you wanted to F him, to stop him, to impeach him? And do you see why that might call into question everything you've touched on all of those investigations? Chairman, I'm done with this witness, and I yield back.
Mr. Chairman, if I can respond.
Briefly.
Sir, well, there are several questions, and I'll answer them all briefly.
There were several
First,
statements. I only heard one question.
fair enough. First, I understand why people might think that, particularly based on the misrepresentations of extreme folks in the media, conspiracy theorists, folks in this body and elsewhere. And that's why I'm glad to be here today publicly, why I'm glad to hear that people are calling for the release of my private interview so that people can judge for themselves who I am, what I said, and the facts, and not something that's being spun or misrepresented in some 10 o'clock talk show or other place. So absolutely, I can understand that, and I'm glad that the facts are coming out. Second, sir, to your earlier point about, I never, and I am unaware of any case being opened that represented some violation of civil liberties or a removal of due process rights. I have never done any activity, opened any case with regard to that. And when you look in the context of what had occurred, sir, during the time that Director Comey had been fired, where the president said initially that that had occurred because of a memorandum written by the Deputy Attorney General looking at his conduct in the Clinton investigation, and then days afterwards pivoting and telling Russian diplomats and Lester Holt that it was because of the Russia investigation and a huge burden had been taken off his shoulders. We all were very concerned about, from an investigative standpoint, the pace and severity and the unprecedented nature of facts and events that were unfolding, and our investigative
Mr. Strzok, I did say briefly.
To go, I appreciate that, Mr. Chairman. I'm
Mr.
wrapping
Strzok,
up.
in that regard, though,
desire to lock things in before things change was very important to us.
Pointed to your response, however, and in the interest of full transparency, and to Mr. Ratcliffe's point, will you authorize the release of all of the other text messages that have not been released to the Congress to this point?
Sir, I would authorize the release of any work-related text messages that are out there.
But the question is, what's work-related and what is not?
That's right, sir. And I would not accept or agree to the release of non-work-related text messages.
Even though your testimony is that you would never let your work interfere with your personal opinion.
That is exactly my testimony.
So how are we going to know that unless we see those text messages?
Well, the Inspector General, very carefully, an independent body, went exhaustively through the entirety of that body and found, sir, that there were no acts of bias, that there was nothing demonstrable.
Inspector General worked for an entirely different entity than the United States Congress. Will you authorize release of them to the United States Congress?
No, sir.
Mr. Chairman, point of inquiry. I'm trying to understand his answer. My understanding was that the Inspector General did not see what he is claiming to be his personal text, that they were requested and he delivered what he said was business related. So if I understand correctly, no one has seen anything that he determined, Mr. Strzok determined, would not be delivered because in his opinion, they were not business related. I have a number of texts in front of me that I would say were very personal that we're looking at that undoubtedly he would have objected to turning over.
The gentleman makes a very good point. He may want to ask questions about that when he is shortly to be recognized. But first, we're going to recognize the gentlewoman from Texas, Ms. Jackson Lee, for 5 minutes.
Mr. Chairman, thank you very much. I'm sorry my colleague walked out before Mr. Strzok could give his answers. I hate no one. I do not hate the administration, the president, my colleagues. In fact, I love this nation. I honor this nation. And so I believe it is important that we stand on the force of truth in the Constitution. In the oversight of these two committees, it is unfortunate that none of these committees, Judiciary or Oversight, have decided to pursue more precious or more important issues than asking about Hillary Clinton's emails, which have been well documented, that there was no criminal impact, and in essence, she was vindicated by the Inspector General's report and other reports. Unfortunately, this has become a fishing expedition. What we have not done is investigated the children being stolen away from their families, nor have we looked at our president meeting with Mr. Putin, getting his annual performance review while offending our NATO allies. Foreign policy scholars are aghast that this president, one who famously refused to read his briefing materials, will be meeting with Mr. Putin. In addition, we're wasting time doing the Clinton investigation rather than investigating the role that Russia played in the 2016 elections. Unanimous and unassailable assessment of the intelligence community is that the Russians helped Trump over Hillary and intended to harm her. In the judgment of the Republican-controlled Senate Intelligence Committee, they agreed with that assessment. Unfortunately, the President and House Republicans do not agree. The leader of Russia is known to have sanctioned murder of dissidents, jailed journalists, and this is the president who is described as easy to meet with. Neither the Judiciary Committee or the Oversight Committee has investigated the president's indicating that he can pardon himself. So here we are, Mr. Strzok, to ask you questions. I saw you in the closed session. I think you're a credible witness, and I believe you love America. My questions only require yes or no. Did anything you did or say in 2016 change the fact that Trump campaign associate Carter Page was under counterintelligence surveillance going back to 2013? Anything that you did, yes or no, sir?
No.
Did anything you did or say in 2016 change the fact that in March 2016, the president met with George Papadopoulos, who would later plead guilty for lying to the FBI?
No.
Did anything you did or say in 2016 change the fact that Donald Trump Jr. met with agents of the Russian government in Trump Tower in 2016?
No.
Did anything you did or say in 2016 change the fact that the president asked Russians to hack into Hillary Clinton's emails?
No.
Did anything you did or say in 2016 change the fact that Paul Manafort, who has pleaded guilty, in fact, that in July 2016 that Paul Manafort changed the GOP party platform at the 2016 GOP convention in order to benefit Russia, or change the platform?
Ma'am, without saying whether or not that's accurate, no.
Did anything you did or say in 2016 change the fact that in May 2016, George Papadopoulos was drunk in a London bar bragging about how Russians had dirt on Hillary Clinton?
Again, ma'am, without confirming whether or not that's accurate, no.
Did anything you do or say in 2016 change the fact that when Donald Trump was presented with dirt on Hillary Clinton, he responded, "I love it"?
Again, ma'am, only commenting on public accounts of that, no.
Did anything in the IG report change the fact that Donald Trump Jr. was communicating with WikiLeaks' Julian Assange about the timing of releasing emails designed to harm Hillary Clinton? Anything you do?
Anything I did, no.
You're well aware that Mr. Flynn has pleaded guilty. Is that not correct?
That's correct.
You're well aware that he was a national security advisor for the President of the United States.
That's correct.
Well, in his offense statement that we have right here, Mr. Flynn indicated that his statements, false statements and omissions, caused impeding the Russian investigation. But more importantly, I believe it's important to take note of the fact that he provided information to the Russian ambassador that said, here, calm down. Don't bother to get upset about sanctions. And according to a whistleblower, he said the sanctions would be, quote, ripped up to allow money to start flowing to one of Flynn's business projects. You had no interference with that, did you not?
I did not.
And you had no involvement, if you will. During your June 2018 interview, I noticed some concern in your voice when recalling the 2016 campaign season, specifically October 2016, and specifically as it relates to the state of Trump-Russia investigation. Why were you so concerned about what was happening at that time?
I'm sorry, ma'am, would you rephrase that question?
During your June 2018 interview, I noticed some concern in your voice when recalling the 2016 campaign season, specifically October 2016, and specifically as it relates to the state of the Trump-Russia investigation. Why were you so concerned about what was happening at that time?
Well, I think trying to keep this at a level, not talking about open investigations.
Only
yes, ma'am. So the predicating information, the information we had, which was alleging a Russian offer of assistance to a member of the Trump campaign, was of extraordinary significance. It was credible. It was from an extraordinarily sensitive and credible source. And as we looked at what that represented, the key time was obviously coming into the election. And so for us, there was absolutely a need to, one, this was a serious allegation, two, of extraordinary gravity, and three, given the fact that the election was upon us and that if, in fact, then candidate Trump were elected, that whether he or certainly more likely or possibly members of his campaign were actively working with the Russians, we needed to get to the bottom of that. It could be that none of them were. It could be that some, or it could be on a far worse scale, but the urgency for us to understand what was going on in advance of the election and certainly in advance of any inauguration, I can't overstate the importance of that.
I thank you, Mr. Chairman. May I put into the record, I ask unanimous consent to put into the record articles, including the one by Chris Saliza, no evidence struck bias the investigation in any meaningful way.
Without objection.
I thank you, and the patriotism of this witness and all of us should indicate that certainly Russian
The time of the
involvement in
gentleman
election
has
is priority.
expired.
I yield back. Thank you.
The gentleman just answered questions regarding the substance of the Trump-Russia collusion investigation. We have many more questions that we are entitled to ask, and the gentleman is responsible for answering with regard to the onset of that investigation. We are not interested in the substance of Mr. Mueller's investigation, but the manner in which it was created and your involvement in that is very much directly related to that. So when we return, we will have more questions for you regarding that, as we indicated earlier. Now the committee will stand in recess for votes, and we will reconvene at 2 p.m.
Yes. So we're going to head to how long? Yeah. We're at 4 minutes. 3 minutes. Okay, so that way is actually All right, Lucas, see you in a bit.